mile, 18 mile, that may be called for blanch.
Settlement of market. Settlement of market. It was notice or it was on 19th. So my prayer it may be common.
Settlement of market. You mentioned before the senior judge.
4 and 5 euro lot. 4 and 5.
I'm taking a 4 and 5, but there is a somebody in 4 with the senior judge who is taking 4.
4 you lost to it.
Only me. I'm only taking 4.
As per Rota, I have 10 million lost to it.
Okay. Yes, when do you want?
Wednesday or Friday?
Okay.
Harshab, I'd like to mention in the BPC matter pertaining to establishment of brick industry. Matter may be taken on Wednesday.
Friday.
Next.
Item number 40, Lordship, there is a personal appearance of the Deputy Commissioner Udalguri in item 40. He has come. Can it be taken in the first half only?
Yes. Personal appearance will take it as the first item.
Lordship. This is the contempt matter. The order Lordship will find in the contempt petition dated 24/3/2017.
Wait, first and foremost, what is the case about?
Case is about assessment of the compensation, land compensation, and the Power Grid Corporation has drawn some power
They
line.
are filing a contempt
They have filed a contempt
against the order passed in.
in
WPC
WPC 1769 of 2017.
Let's see the order. 24/3/2017.
24/3/2017.
What is the order on the
They-
refusal of the contempt of the president? Yes.
Well, the Deputy Commissioner, now the present Deputy Commissioner has joined in his post in the month of August 2022. Well, the earlier Deputy Commissioner has filed an affidavit in the matter, stating that in the particular place is within BTC area, and the BTC authority is the competent authority to assess the land compensation. So DC has no
This is not a land company, this is a right of way.
right of way. Correct.
under the Telegraph Act.
Telegraph Act.
So if it is under the Telegraph Act, who is going to do? There has to be a person who is the competent authority.
Malad,
Who is the competent authority?
in fact, the communication is there, Malad. The Deputy Chief BTC, they have, in fact, the BTC authority held a meeting, and particularly in respect of this work for drawing of electricity line by Power Grid, they have said that the BTC authority will be doing whatever compensation is to be given to whom.
And what
They-
is the Deputy Commissioner going to do?
Deputy Commissioner has no role. Malad. In fact, Deputy Commissioner cannot do. They are the BTC.
So there has to be somebody appointed as a competent authority as per the Act. Yes, Mr. Counsel, you are there.
Yes, Lord.
What is the Act? To me, the Act. Telegraph Act.
But the Telegraph Act, Lordship, the district judge is the
District judge will be the appellate authority. But it will be the local authority. The local authority will be as defined under 2737, which defines local authority to mean any municipal committee, district board, body of board commissioner, or other authority legally entitled to or entrusted by the central or the state government with the control or management of any municipal or local fund.
Well, the BTC authority, they have, in fact, the Ministry of Law and Justice has issued the gazette notification by which the sixth schedule to the Constitution has been amended, and that particular the power in respect of land and revenue, well, that has been given to the BTC authority. And now the BTC authority, they have on 17/8/2016, there is a minute, Malad. This minute, Malad, I'm sorry, Malad, I have one copy. The meeting was chaired by the Honorable Deputy Chief BTC. He welcomed all the executive members and officers present in the meeting. While discussing the issue raised by Power Grid Corporation of India Limited and guidelines issued by the Government of India via number so and so dated 15th of October 2015, the Honorable Deputy Chief BTC took stock of the ground situation from the circle officers of the affected areas in the meeting, and it was decided that henceforth land valuation of land would be assessed by circle officers of concerned revenue circles in the BTC area as per aforementioned guidelines received from the Government of Assam. However, the valuation of land evaluated by circle officers of concerned revenue circles would be finally approved by the BTC, and on the basis of approved land valuation,
Under whom is the circle officer?
circle officers are
Is under whom?
circle officers are
Good morning, sir. Sir, I'm District Commissioner Udalguri. Circle officers are under the BTC authority only.
Not under the DC?
They are not with us. The revenue and land matters are completely with the BTC government under the sixth schedule.
Hello, what I have seen in this contempt petition, the respondent number 3 is the principal secretary BTC is the party.
They have entered appearance, but on last occasion, they were absent, Lord.
Who?
Respond number 3. On behalf of respond number 3.
Is he still there?
Possibly, Viren Chandra Kupan is not there. Who is the principal secretary now?
Who is the
Akash-
principal secretary now?
Sir, he is Mr. Akash Deep, Principal Secretary.
Present secretary is Akash.
Oh, 18.
Problem arises because there were specific directions to the
Yes.
deputy commissioner.
Lordship.
That is precisely the case. On last occasion, Lordship was of the opinion that since there is an order to that effect, that the deputy commissioner has to do the needful. Since they have not come up in review or they have not filed any application for modification, that order stays.
But
That
can
is
the
why-
deputy commissioner do if there is no power? Huh? I may give a direction that tomorrow this person will do, but if he doesn't have the power, can he exercise that?
because
Would
of-
the issuance of the writ be not be a futile one, or isn't it a requirement of an amendment to the writ? Because these are specific directions given to the deputy commissioner, and the deputy commissioner is not in a position to do that.
Well, the earlier affidavit in the matter was filed.
Because here is a case of contempt. Now, if it is a case of contempt, the contempt will be if there is a willful violation.
Correct.
Now, can there be a willful violation on the part of the deputy commissioner if he is not in a position to exercise that? Isn't it?
that
Then-
instruction will have to come from respondent number 3.
Understood. Respondent number 3, that person is no longer there.
Well, these things are
So
not.
how can this court impose upon the deputy commissioner to do something which he has no power to do?
In all fairness, Lordship, then it was incumbent on his part to file appropriate application for modification of that order, Lord.
Understood.
That is
No,
precisely
that
the
is,
case why the
no,
person
that is
of the
understood.
district
No,
commissioner
Mr.
was
Counsel,
called
that,
on the
that
last
very
occasion.
aspect is understood. But can this court, because you see, in order to hold him in contempt, because this is a contempt proceeding, there has to be a willful disobedience to the court's order. But can it be said to be willful if he is not in a position to exercise that power?
In fact, in regard to these subject matters, some other orders have also been passed where direction has not been specifically given to the district commissioner to.
Understood. If specific other orders are passed very well, then it is better. But here the deputy commissioner has been directed. And you have not now made the principal secretary a party, present one.
May be allowed to implement them.
In fact, the present
I
DC is
can't
also
make
not a
you
party.
allow you. You have to inform him. Because there is a question of willful disobedience. So you have to give him an opportunity. And if he fails to do so, then only it can happen. Yes, what is that document you were referring to?
Well, can I just
Committee minor. Now, what is this? The second line. Honorable Deputy Chief BTC requested the Land Revenue Department to request the Deputy Commissioners of the 4 districts of BTC to help in completing the remaining works of the Power Grid Corporation Limited in all the districts. So that means the Deputy Commissioner have something to do.
law and order on all these things, maybe, my lord. But for assessment, they in the first paragraph they have made it clear that circle officers and the BTC approve, they will approve, they will do. Because sometimes when a law and order problem arises while drawing the line, in that case, deputy commissioner may have to help. And they have also appointed the nodal officer. my lord. Nodal officer from Secretary BTC is the nodal officer.
And have you made the circle officer a party?
No, circle officer
No.
is not a part.
And this Dilip Kumar Das is not there.
Dilip Kumar Das was earlier, he was the DC.
You have not implemented him.
No. But in fact, in view of the last honorable court, last order of the honorable court, application we have prepared, and if necessary, my lord, from the petitioner side, he could have done it long back. He can also do, but we have already for modification of the order, since the affidavit of the deputy commissioner is already there on record, that he is not the authority, my lord. And the documents are already there. But he has not done. But since we have prepared an affidavit, the application for modification of the order, the review of the order, in fact,
You have filed it?
that we have prepared. We have discussed and we have prepared. We are filing it. Ultimately, the order has to be complied with.
No. Pursuant to the order passed by this court on 10/11/2023, Mr. Your name?
Satyanek,
So and so, the Deputy Commissioner, Udalguri, is present before this court. He submitted that the office of the Deputy Commissioner has no role to play as regards the assessment of the compensation, taking into account the area, taking into account that the office of the Deputy Commissioner is not a local authority within the meaning of section 37
37.
of the Indian Telegraph Act 1885. He, however, submitted that on the basis of a minutes of a meeting forwarded to him, this is a land for which, why is the Udalguri Deputy Commissioner here? Here only the Deputy Commissioner Kukrazar is there. Kukrazar, the line went through Kukrazar, Udalguri everywhere.
From Biswanath Charyali to Bongaigaon. Through Udalguri. The order, honorable court order, which was relied for passing the judgment, the 24/3/2017, that belongs to Bongaigaon district. That is why the DC Bongaigaon was directed.
Of minutes of the meeting, which was forwarded to him, dated 8th of August 2016. It is clear that the circle officers of the affected areas were required to make the land valuation. And upon making such valuation, the same is required to be finally approved by the Boroland Territorial Council on the basis of the approved land valuation. He further submitted that as the office of the as the deputy commissioner of the district of a district coming within the BTAD area is not the local authority, the directions so passed in the order dated 24/3/2017 in WPC number 1769/2017 cannot be complied with by the deputy commissioner, complied with by him as a deputy by him. And it is only the BTC authorities who can do so. This court have also taken note of that the respondent number 3 and respondent number 4 are no longer serving as the Principal Secretary, Boroland Territorial Council, as well as the Deputy Commissioner, Udalguri, respectively. The Legal Counsel, appearing on behalf of the petitioner, submits that he may be given the liberty to take appropriate steps against the new incumbents to the said offices. It has also been submitted by Mr. D. Nath, appearing on behalf of the Deputy Commissioner, Udalguri, the present Deputy Commissioner, Udalguri, that the said Deputy Commissioner, that steps have been taken seeking review of the order dated 24/3/2017 in WPC number 1769/2017, so that the directions which have been issued could be modified. Taking into account the above, this court therefore fixes this matter fixes this matter again on 22nd of January 2024. In the meantime, the petitioner is given the liberty to take appropriate steps. This court, upon hearing Mr. So-and-so, the Deputy Commissioner, Udalguri, and taking into account the provisions of the Indian Telegraph Act 1855. 1855, no? Oh, 1885. Dispenses with the personal appearance of so-and-so. List according.
Lordship.
For counsel, you need to, in view of that affidavit, you need to file an IA or file a review. I think the review would be the proper one for getting an effective. Otherwise, your writ petition would become useless. They are filing a review. You are filing?
Yes,
Serious. Seriously.
we have prepared. We have prepared.
Next.
In fact, the petitioner ought to have filed on 11/2/2019. We have filed the affidavit. It is known to him,
You file now.
or he can also file with us.
You are filing.
Lordship, Lordship. We have already taken.
I have already mentioned.
I have already taken steps. Logic. Of logic.
Thank you.
True one for drill.
Yes, madam.
My instruction is to withdraw the matter.
The learned counsel, Miss P. Bhattacharjee, appearing on behalf of the petitioner, submits that she has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. No interim order?
No, Lord.
Item number 2 for motion.
Kindly peruse the last call.
Hey, mine. Okay.
Yes.
Lordship, the minute for the meeting has been sent to us, Lordship.
What are you challenging, Mr. Bhattakur?
Lordship, the
Announcement of
decision, your lordship, to enhance the
How much
Right.
you are paying now?
square feet, it was your lordship 2.
Huh?
Square feet, it was 2.
Now,
Now they have increased it to rupees square feet 10.
where is it?
Your lordship will kindly come to page 65. That
And
is
when
only-
was it two?
This was the minute.
When was it two?
Before your lordship, this new rate has been fixed. Pursuant to your lordship.
Understood. Since when it
till-
has been
till
two?
March, your lordship.
Since when it was,
That
Two.
your lordship will kindly.
when have you entered into?
Lordship, it's long.
When have you been paying this 2 rupees?
Lordship. I have mentioned this to your lordship. That when
And
I-
what is the market value there? Rental value?
That is what your lordship, your lordship was supposed to place before this honorable court, your lordship. Annual rental value they have to calculate, your lordship. On the basis of that, your lordship is,
How much were you paying earlier?
your lordship, it was square feet 2.
How much?
Your lordship, this is not only for one person, your lordship. This is different for different persons, your lordship.
Huh?
This will be different for different persons, your lordship.
Understood. Which persons you are before this court? The 7 persons?
Lordship.
How much you are paying for each?
That we have not mentioned, only
Then
your lordship that.
Why should this court look into all these things?
No,
This is-
your
this is a
lordship.
material fact, Mr. Bhattakur.
Lordship, we are saying that this is 2 per rupees 2 per square feet. We are paying.
Understood. How much were you paying earlier?
Lordship,
You don't know.
Your lordship, I will, your lordship, if necessary, I will file it. My case is not that, your lordship. My
Your case is that this was done without proper procedure.
Yes, lordship. That
We
much,
will
your
look
lordship.
into it whether it is proper procedure or not. First of all, you satisfy this court. Why should we exercise a writ?
Lordship, because your lordship, this is.
There
the
has
ma-
to be a convenience, inconvenience question out here.
Your lordship will
This
kindly
court
see,
find
your
no
lordship,
good reason.
the manner in which they have.
You were paying 2. Since when?
Your
Since
lordship,
when?
I,
If it was from 1983, 2 rupees, now they are making it 10 rupees. Then
no, your lordship, if it is stand by following the procedure prescribed by the law, your lordship, we don't have any case.
what is the procedure?
Your lordship will kindly see that
Yes, where is it?
from your lordship.
Now,
Starts
Assam
from
Municipal
your
Act.
lordship, municipal act, your lordship.
Assam Municipal Act. Yes,
It's chapter 5, your lordship, municipal taxation, your lordship. Section 68, your lordship, the power to levy tax, your lordship.
tax is different.
Lordship, tax on holding.
Hmm?
Your lordship may kindly come to page 7,
No, what you were allotted certain shops.
Lord.
And the rent was fixed at a particular rate.
Lord.
So that rent,
Lord.
they have increased it to rupees 10.
That, yeah.
Then
Lord,
what is wrong?
wrong, your lordship, that my case is that they have not, your lordship will kindly come to page section
Don't-
79.
Yes. This is for holding. Holding has no value. Holding and allotment is a different aspect.
Your lordship will kindly see the ultimately, your lordship, this is the basis on which they, your lordship.
Are you saying that the rental value
Yes,
at which the rent will be given to you shall be based upon the determination of the annual value for the purpose of assessment of a holding?
lordship will
Absolutely
kindly,
no.
your lordship will kindly see 79C, your lordship.
I've seen it.
79C, your lordship.
Hmm.
Power to fix the rental value and the annual rental value.
Hmm.
The rate of rental value per square feet shall be fixed by the board of the municipality at a meeting with prior approval of the committee mentioned under section 79A.
Hmm.
Now 79A, your lordship says, your lordship, the committee, your lordship. That has, my case is that this committee has not approved this, your lordship, number one. Then your lordship, and the annual rental value shall be communicated.
You have been given this thing under what provision? The leasing out is done under 63 Act.
Lordship.
Yes. Then
This is the act, your lordship, 56.
63, power to purchase, lease, sell land.
Lord.
A board may at a meeting purchase or take or lease or give any land for the purpose execution. The board may enter into and perform any contract necessary for the purpose. Every contract made when any sum of money involving 500 shall be sanctioned by a board and shall be in writing and signed by at least 2 members. Transfer of certain public institute to the board.
As per my instruction, lordship, it was done under 148(2).
148.
The board, if decided in a meeting, may levy the rent, toll, and
Rent, tools and fees. Board, if decided in a meeting, may use their own land or with the building or purchase taken on meeting. Otherwise, a meeting will be rent. Good for sale, the house and dairy and regulate. Yes, then
Lord.
no case.
Ultimately, your lordship will kindly think, your lordship.
There is a difference. For fixation of the rental value for the purpose of assessment of a holding cannot be the same for the purpose of leasing out particular spaces for the purpose and taking on rent.
At the end of the day, your lordship, there must be some, your lordship, methodology they will have to adopt for fixing the rent, your lordship.
So therefore, the question arises is as to whether your rent, which you were paying at that point of time,
Lord.
and the rent which has been now is exorbitant,
No,
and for which it is in violation of Article 14.
lordship,
That would be a case if it is excessive. But can you challenge on the basis of 79C, which has now no nexus?
ultimately, your lordship, they will have to follow that particular, your lordship.
Absolutely no.
Otherwise, your lordship, there is no procedure laid down in this particular.
Not necessary.
case, your lordship.
They may fix
Let
the
me,
rent,
your lordship,
and if it is exorbitant, then obviously you have a right to challenge. But you have not mentioned how much you have paid.
No, your lordship,
Yeah.
that's why I
And
have
since when you have been paying? That is why I put you the specific question.
Your lordship, I will, your lordship, file an additional affidavit, your lordship. To that extent, I will be given some time on Friday, your lordship. By Friday, I will bring everything into record, your lordship.
as per my
And
instruction,
thereafter, if your lordship.
Yes. What is it?
it was increased after 6 years. It was increased after 6 years.
6 years. Very good. And what is the present market value?
Lordship,
That is not, they have
That
not
is-
calculated that, your lordship. That's the case, your lordship.
I won't disturb you as of now. This court doesn't find it a fit case for issuance of a notice till date. So you want to file an affidavit.
Since your lordship has put certain queries to me, I will bring that file.
The learned counsel, Mr. Iyalapo, Pursuant to the order dated 10/11/2023, Mr. S.S. Roy, Learned Counsel, appearing on behalf of the Urban
Lordship.
Huh?
Urban Development.
Development Department of the Government of Assam, have obtained certain instructions. Be that as it may, this court, in absence of certain material particulars being set out in the writ petition, does not find this case a fit case for even issuance of a notice. Mr. S. Botako, the Learned Counsel, submits that he would like to file an additional affidavit bringing on record such material facts. List the matter again on Friday. You get your instructions only one thing, to the effect that what is the method employed?
Lordship.
Because this is purely a case between you giving it. The 79C does not.
Number 3, Deputy Obligor.
Wait, Your Lord.
Mm.
The petition of my vehicle, my lord, and non-payment of the bill is the subject matter of this.
Non-payment?
Non-payment of the bill.
Why?
Lordship.
Lordship, they've already filed an affidavit, my lord. It is not on record, but we've given a copy, my lord, of the affidavit.
Affidavit file.
The
Lordship.
And
respondent
the matter has come up for motion.
Lordship.
already noticed was issued, my lord.
And what is your stand?
Lordship, it's a 10 lordship that we have admitted amount, we have paid some amount lordship, this balance we have not yet received this.
How much you have to pay?
18 lakhs or we have paid lordship.
And you have to pay remaining 70 lakhs.
Lordship, not lordship, his bill was of 89 lakhs something and we have paid 18 lakhs now as of now.
Understood? So remaining is 70 lakhs 64,090.
Lordship is the balance.
We dispose it of.
Lordship.
The instant writ petition has been filed by the petitioner. Challenging the inaction on the part of the respondent authorities in not releasing the dues to which he is entitled to. Entitled to on account of giving on hire his vehicles, or on account of the vehicles of the petitioner being taken on hire by the respondent authorities. It reveals from the records that the petitioner owns 4 vehicles bearing registration number AS16A /2277, AS01BG /2277, AS16F 1333. Whatever, where is the 4th?
Lord, AS16B 9777.
Where is it?
Very in the synopsis.
Paragraph number 4, page number 4, you have not mentioned. And
A16B, my lord. Line number
AS
16.
16B 9777. The said vehicles were taken on hire by the superintendent of police. Which one? Kokrajhar.
Kokrajhar, Lord.
Kokrajhar. And the petitioner duly submitted bills amounting to rupees 69 lakhs 6,437. However, as the said bills were not released on time, the petitioner even submitted a notice. In spite of the said notice, the respondents have not cleared the said amount of rupees 69 lakh 6,437. for which the instant writ petition has been filed seeking the said amount along with interests and compensation. The record reveals that this court, by an order dated 18/10/2023, submitted that the issue sought for the instructions as to whether the petitioner is entitled to the said amount or not. It is further seen that an affidavit in opposition was filed by the Additional Superintendent of Police, HQ, Kokrajhar, wherein it has been mentioned at paragraph number 6 that the competent authority had hired the vehicles from the petitioner for the use of the respondent for the interest of public service and maintaining the law and order situation. It was mentioned that the Additional Superintendent of Police, Headquarters, Kokrajhar, had no authority to sanction the higher charges bills, and accordingly all the higher charges bills were forwarded to the office of the Assam Police Headquarters, Ulubari, Guwahati, on different occasions to memo for necessary sanction and release of funds for total admissible amount of 89,47,953. It was further mentioned that the petitioner had received an amount of rupees 18,83,663. I've heard the learned counsels appearing on behalf of the parties. This court, however, finds it relevant to take note of the submission of Mr. S. S. Roy, the learned counsel appearing on behalf of the respondent state, who submits that taking into account that the petitioner have claimed an amount of rupees 69 lakhs 6,437 and the affidavit filed by the Additional Superintendent of Police, HQ, Kokrajhar, states that the petitioner is entitled to an larger amount, is entitled to an amount of rupees, was entitled to an amount of rupees 89 lakhs 47,953, and of which an amount of rupees 18 lakhs 83,663 has been paid. The respondent authorities, more particularly the DGP, the respondent number 2, would require, more particularly the respondent number 2, would have to verify the actual entitlement of the petitioners. He submits that some time may be given for making necessary verification, and thereupon, if it is found that the petitioner is entitled to any amount, the same be paid to the petitioner. Taking into account the pleadings, including the affidavit filed by the Additional Superintendent of Police, Kokrajhar, this court is of the opinion that a verification would be required as to ascertain the actual entitlement of the petitioner. Accordingly, this court directs the Director General of Police, Ulubari, either by himself or through his delegate, verify the actual entitlement of the petitioner, and thereupon, if it is found that the petitioner is entitled to the amount claimed or any part thereof, the same be released to the petitioner. The said exercise be completed within a period of how much?
3 months, Lord.
6 months from the date of service of the certified copy of the order.
Anna four.
Lordship, here your lordship relates to property tax under the municipal about your lordship. And your lordship, in fact, we are filing an additional affidavit today, your lordship, and detailing the violation that has taken place. This, your lordship, is covered by your lordship section 79, your lordship.
Huh?
Property tax. For the first time, they have imposed. This is a newly constituted municipal court, your lordship.
Okay.
Earlier, it was a
So
Panchayat
this is under 79.
79.
This is for property tax.
Property tax. Your lordship may take it up on Friday, your lordship, along with my affidavit.
Why?
Because your lordship, in the affidavit, I am detailing your lordship the violation that has taken place.
You have not mentioned.
Some your lordship, details, your lordship, in details, I have not mentioned.
Your Lord. The learned counsel appearing on behalf of the petitioner seeks for an accommodation for filing an additional affidavit bringing on record certain additional facts. List the matter again on
My lord,
Friday.
24th of
my
November.
lord, only thing, if I may most humbly draw your lordship's attention, my lord, this is proxy litigation. My lord, the prayer is very clear. The entire list, it is two petitioners and they want the entire list. Entire list of people who have been outlined that property tax would be imposed. Kindly see the prayer, my lord, page 13 of your lordship's brief. And also he relies on a Pangrami representation. He is a secretary of that organization. What that organization is not known. Under what law it is registered as an organization. Page 20 and page 13, my lord. Whether it is not at all entertainable by the Honorable Court.
Your lordship can always mold that, your lordship. I will have to.
And or the impugned list of owners not to act.
Your lordship can always mold it, your lordship.
No, my lord. Proxy litigation, my lord.
Okay. He wants to file an additional affidavit. This court is yet to issue notice. And I have not disturbed you.
I know. Obliged, lord.
Deeply obliged.
Made with the lordship.
Hmm.
This is with respect to a contract, your lordship, a tender. The same was issued and then we had submitted our earnest money, your lordship. However, we could not submit our complete earnest money. That is 15,40,000.
Wait.
Because of
What
technical
is
glitch in the
your
website.
case? What is your case?
Your lordship, there was a tender with respect to Kopati mining contract area.
Ah.
We were the intending tender. We had submitted a bid, but when we were submitting our earnest money, due to the technical difficulties, your lordship, we could not submit the 15,40,000 rupees
Within time.
within.
Then they rejected it.
They didn't, we don't know, your lordship, what they did. They didn't.
It is a take instruction because the technical glitch, your lordship. What happens after that, we don't know.
When
Because-
is the technical opened?
It was payment of participation fee remaining. It was on 18/9/2023. Opening and evaluation technical bid stage 1 on 16/10/2023, your lordship.
And they have approached now?
Yes, your lordship.
Okay. Issue notice?
Yes.
Issue notice making it returnable. How long? When can you get your instructions?
Up to 2 weeks.
Not so long. In the meantime, 2 weeks, the work will be over. Friday.
Friday, your lordship. That will-
This is the issue notice making it returnable on 24/11/2023. Mr. R. Gogoi,
R. Gogoi, lord.
double R. Mr. Double R. Gogoi appears and accepts notice on behalf of the respondent number 1 to 4. Extra copies of the writ petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner had, in pursuance to a notice inviting tender dated 18/9/2023, pursuant to a notice inviting tender dated 18/9/2023, submitted his bid, but on account of certain difficulties, the said earnest money could not be deposited. Did you deposit?
We had deposited 11 lakhs out of the 15,45,000.
He further submits that out of the amount of rupees 30,80,000, only an amount of rupees 11 lakhs was submitted. 11 lakhs could be submitted.
Yes.
The remaining could not be submitted on account of malfunction, technical manufacture and error and glitch in the official website of www.assamforestonline.in. He submits that on the ground that as the petitioner could not submit the online, could not submit the entire earnest deposit on account of a fault of the respondent department. The e-auction notice dated 18/9/2023 be set aside and quashed and direct the respondents to reissue the fresh tender in respect of NKD-M-16 Opati Mining Contract Area. Mr. R.R. Gogoi shall obtain the necessary instruction as to whether there was any technical glitch which resulted, for which the petitioner was not, technical glitch in the website of Assam Today, www.
Public note. Deeply okay.
Number 6.
Last occasion, government advocate was to obtain instruction regarding the compensation amount.
Instructions so directed to be obtained have not been obtained for a short accommodation regarding the status of the acquisition as well as the compensation. Yes, what instruction? With reference, I would like to inform you. These are matters of 2015. And till now, you have not released.
2019, they filed an affidavit stating that some of the petitioners have been paid, and in respect of some other petitioners, they are making the due inquiry and they are.
And it is the same.
My lord, that 2283 left-hand side first column, these
Huh?
persons in the instruction first page, my lord. The first column, these are the petitioners number
Who have received.
yes, compensation awarded. my
Yes,
lord.
as regards the other petitioners, some no records available.
And
No records available means either they will be within the part of the compensation package or not. So they will be a part within the 3G, 3D notification. Are these petitioners there?
that information, I require some more time.
What
my lord.
more time?
And so far as 6 and 11.
And requirement for fund has been made in the last occasion also. Have you made the payment in respect of 6 and 11? Why you are asking? Yes. What is wrong with you? Why you have not made the payment?
Lordship, in earlier occasions, whatever the Kala has recommended to the.
That was given to, this is a matter of 2015. Does it look nice on your part to do this?
That notice which have been served to us on last 14 years, Lordship.
Huh?
This notice which have been served to us as per the instruction.
Huh?
Communication on 14 November.
Then?
Thereafter, it my.
No,
as
no,
per my
no, no,
instruction,
no,
it has
no,
been
no,
approved
no,
the higher
no,
authority for
Mr.
sanction.
Counsel, this court is not to that. Kindly come to the affidavit filed on 27th of November 2019 by the respondent number 5. Now, out of this, 6 and 11 still remain. Others have been paid. What is this 6 and 11 again? Why 6 and 11 continues to remain? See your instruction, this instruction and that instruction, page 77.
Yes.
Because in the additional list will be compensated and after approval of the 3G and receipt of fund. Now, of this, some receipt was made. And as such, 13, 20, 21, these people come within the ambit of the first one, of this one. Okay, but why 6 and 11 is not there? Although there was a list given. Why there was 2 separate funds again sent?
My lord, in affidavit also 611 that additional fund requirement was mentioned, my lord.
No.
6 and 11.
Understood.
My lord.
Fund requirement was made for 6, 11, 13, 20, 21. But all the others have got it. 13 to 63, they have got it. Only 6 and 11 remain as per the present list. Why? As regards those records not available for this one, these, all these things, they remain the same.
Yes, my lord.
Then and Mr. Counsel, why are you not approaching the district judge? What is all these things? Filing a writ petition before this court unnecessarily.
That I have no impact.
No, you don't hear instruction. No, the petition should be dismissed on that count. Isn't that the law? If you are entitled and they have not given you, if you are entitled and they have said that yes, you are entitled to, very well. This court can pass an order to that effect, kindly give them. But if they held that there is no records available as far back as in 2019, what is stopping you from approaching the concerned authority that you are entitled to? And how can this court decide under 226? And this is the reason, the problem in the first matter. That is the reason. You can't keep on filing writ petitions in this manner. How can this court decide all other aspects of the matter? As regards the petitioners, 1, 24, 26, 32, 43, 46, 47, 63, 68, 69, 70, 76, 79, and 80, they remain the same. There is no records available. Then under what circumstances can you get it? Tell me. Not possible. Have you looked into the National Highways Act before filing the writ petition? No. Then, without looking into the act or provisions of law, why do you file writ petitions? My goodness. As regards petitioner 48, 51, and 58, they have not been paid as their father, petitioner's name and father's name are not matching. So you take your steps again. This will be under, your entitlement will be under 3H. You have to file applications. Then, and remaining, these people are doing it. Okay, Leho. Pursuant to the directions passed by this court on 6/11/2023 and 15/11/2023, Ms. M. Burman, the learned junior government advocate, has produced certain instructions. This court, upon comparing the data as it stood in the affidavit filed by the respondent number 5 on 27/11/2019 and the instructions to produce today, finds it relevant to note that the petitioner numbers, that most of the petitioners have received their compensation. However, petition number 6 and 11 is yet to receive compensation, for which requirement of fund for for the said petitioners have already been made to the NHIDCL on 14/11/2023. It further reveals that petition number 48, 51, and 58 have not been paid the compensation as the petitioner's name and the father's name are not matching. However, the instructions in respect to petitioner numbers 1, 24, 26, 32, 40, 46, 47, 48, 70, 74, 76, 79, and 80 remains the same, to the effect that there are no representation and records available. Taking into account the above, this court fixes the matter again on 18th of December 2023, on which date Mr. N.J. Gogoi,
BN Gogol.
B.N. Gogoi, the learned counsel appearing on behalf of NHIDCL, as well as Ms. M. Bormon appearing on behalf of the respondent state, shall apprise as to what is the status of the funds pertaining to the petition number 6 and 11. In respect to the petitioners, numbers 1, 24, 26, 32, 43, 46, 47, 63, 68, 69, 70, 76, 79, and 80, the learned counsel appearing on behalf of the said petitioners submit that liberty may be given to the said petitioners to approach the respondent, to approach the appropriate forum for redressal of the grievance, taking into account that it is the specific stand of the respondents that there are no records available. The learned counsel for the petitioner further submits that as regards the petitioner numbers 48, 51, and 58, the petitioners may be given further liberty to approach the concern, the additional deputy commissioner revenue, Sipsagar, and clarify as regards the discrepancy so noted in the instructions dated 16/11/2023. This court taking into account the learned counsels appearing on behalf of the petitioner, grants the liberty to the said petitioners. That is petitioner number 1, 24, 26, 32, 43, 46, 47, 63, 68, 69, 70, 76, 79, 80, as well as the petitioners 48, 51, and 58. Provided the same is permissible as per the mandate of law. List according. Get your instructions on 6 and 11. Mr. Counsel, not done. 2015, 8 years have gone, you have not even booked out the National Highways Act. I know it's 3H4 and 3H5. You need to file an application. That application will be referred to the district judge. District judge will decide. It's not the manner in which you do.
Section 9.
And number 8.
My lord,
Oh, yes, final report.
my lord, that's certified copy of final report, my lord.
Yes. Final report given. When did you submit?
My lord. Date is, my lord, 19/8/2019.
19/8/2019. Before the court of
My lord.
CGM.
CGM, my lord, Shipsagar.
You take appropriate steps then.
My lord, Chair, but it has to be before designated Tada court, my lord.
Huh?
Case is registered under Tada Act, my lord. It has to be before designated Tada court, my lord. Maybe that judicial magistrate has to forward it.
He will forward it.
Yes.
You make necessary inquiries and take up whatever issue you have regarding it. What can this court do?
A copy of it may be
Yes,
furnished to me, my lord,
yes.
and my lord.
It's a certified copy. It is there. You want a photocopy, you can have it. But it is otherwise you need to take a certified copy now. This is governed by a certified copy, na? By the officer in charge. He has certified it. So if they had filed it, when have you filed it?
My lord, that,
That means that a certified copy has been applied for years. So there was some submission made earlier.
my lord,
There is an additional affidavit has been filed when the final report submitted being so on 19/8/2000 as insufficient evidence.
my lord,
19/8/2019
my lord.
as in, however, the same is not a part of the additional affidavit so produced. Okay. Oh. Taking into account the orders dated 11/10/2023 and 18/10/2023, whereby there was a direction upon the respondent state to produce before this court a certified copy of the final report bearing number 439/2019. Ms. Yudas, the learned counsel, the learned additional senior government advocate today have produced the certified copy of the final report dated 19/8/2019. The said final report is kept on record and marked. The said final report, along with its enclosure, along with its forwarding, is kept on record and marked with the letter X. The petitioner would be at liberty to take certified copy of the said final report.
I maybe furnish a copy of the.
You'll be able to take a certified
Oh.
copy of this. That is why I
Yes.
passed it on. Would be at liberty to take a certified copy of the document marked on marked with the letter X and kept on record. The learned counsel appearing on behalf of the petitioner submits that in view of the said final report being submitted, the petitioner shall the petitioner be granted the liberty to approach the appropriate forum for redressal of his grievances.
My lord, prayer in this petition is that I am not satisfied with the investigation conducted by the police authority. So my prayer is
Understood, but have you
Not
no, that was done in 2017.
my lord.
If that is done in 2017, have you said anything about the final report?
No, my lord, unless and until I get it, my lord. So that is why an opportunity may be given to me.
But can this court decide on that? If it is right or wrong? You
No,
have
no,
to
no.
approach the, if
No,
a
my
final
lord.
report
No,
is
my lord.
given,
I'm not on that, my lord. As per provision of my lord, section 173 from section 8, my lord, even after my lord submission of final report, my lord, and acceptance of the same, police may continue further investigation, my lord. And my lord prayer before this honorable court is to hand over investigation to my lord CBI authority. So in that
no,
view of the
you
matter,
said so in the year 2017.
yes, ma'am.
The report came in 2019.
19.
Now, how can this court look into that aspect of the matter?
No, my lord, we have to see because in this case, court directed for reinvestigation of the matter in the year 2008, and thereafter we do not know what investigation has been carried out by the police authority because the affidavit which has been filed by the superintendent of police does not disclose what investigation they have carried out so far after 2008.
But don't you have to challenge the final report?
Final report, my lord, as such, because this is the third time they have filed a final report, my lord. And my prayer is for handing over the investigation to another authority. So I am not challenging final report now. And that, my lord, prayer cannot be.
Now, once the final report has been given
My lord.
by an investigating agency,
Yes,
and that wouldn't that be require a challenge?
my lord, to that effect, my lord, many of the apex courts are there, my lord. Even after, my lord, submission of final report or 30, and even if, my lord, when the trial is going on, my lord, even in some matters, apex court has directed further investigation by the CPI.
Understood. Further
many cases are
investigation by the CBI, very well. But don't you have to challenge this way?
No, no.
They're saying that the
It- it-
final report has not been done in
No,
a
it is
proper
not
manner.
necessary. Can I place this?
Yes.
my lord?
Hmm.
This, my lord, reported in, my lord, 2023 SCC online SC 515 CPI versus Hemendra Reddy. I'm just reading para 83, my lord. We may summarize our final conclusion as under: even after final report is laid before the magistrate and is accepted, it is permissible for the investigation agency to carry out further investigation in the case. In other words, there is no bar against conducting further investigation under section 173, subsection 8 of the CRPC after the final report submitted under section 173, subsection 2 of the CRPC has been accepted. Prior to carrying out further investigation under section 173, subsection 8 of the CRPC, it is not necessary that the order accepting final report should be reviewed, recalled, or quashed. Further, investigation is merely a continuation of the earlier investigation. Hence, it cannot be said that the accused are being subjected to investigation twice over. Moreover, investigation cannot be put at par with prosecution and punishment so as to fall within the ambit of clause 2 of Article 20 of the Constitution. The principle of double jeopardy would therefore not be applicable to further investigation. 5. There is nothing in the CRPC to suggest that the court is obliged to hear the accused while considering an application.
Understood, Mr. Burley. Everything is understood.
Right.
But which court? No, will be that court.
My lord, even, my lord,
You can very well submit your objection. If a final report is given, even there can be a further investigation be carried out, or even you may ask further investigation to be carried out. But the fact that can this court, wouldn't this court be sitting over the wisdom of that court, which actually, as per the CRPC, is mandated to do?
then,
And that too when there is no...
let this matter be taken up for final hearing, and my lord, after getting a certified copy of the same, if necessary, I will submit an additional repetitive report. Maybe take up immediately next. Because so many cases are there, I will have to place, my lord, the law pertaining to so many cases are there.
Okay, pursuant to the order dated 11/10/2023 and 18/10/2023, Mrs. Yudas, the learned additional senior government advocate, has placed before this court the certified copy of the final report number 439/19 dated 19/8/2019. The same is kept on record and marked with the letter X. Before further proceeding, this court, however, finds it necessary to observe that in the order dated 11/10/2023, it was inadvertently mentioned that the date of the final report to be 19/8/2016, which ought to have been 19/8/2019. Pustak. The Learned Counsel, appearing on behalf of the petitioner, submits that he may be given a copy of the said final report so that he may be in a position to file an additional affidavit if so advised. The registry, the courtmaster of this court is directed to furnish a copy of the said document, which is kept on record and marked the letter X, and thereupon the liberty is given to the petitioner to file an additional affidavit. To list the matter again on 15th of December.
Obliged.
Obliged.
We have to take some time to think inspection certificate. We haven't been able to reach our client, your lordship. We have to take some instructions regarding this. Your lordship. Some time may be given.
Whether any dargah is constructed
My lord,
on the affidavit, it doesn't seem.
my lord, it doesn't, my lord.
In the
it is not
affidavit
there.
itself, they have not explained whether the dargah has been constructed and they have been evicted or not. That's the point.
It was mentioned in paragraph number 3
Three,
that the reserve for allotment in favor of so and so, and that condition was that if the land is not used for purpose for which it was proposed to be allotted, it will revert back to the revenue department. The petitioner has failed to produce the letter dated 23/3/1990 and compliance with the conditions mentioned therein. No steps were taken at any point of time for depositing the premium and getting conversion of the land as miadi.
five also, my lord, that
Mr. Your name? Appearing on behalf of the petitioner submits that the affidavit of the respondent number 5 have been received today, and as such, he would require some time to go through the same. This court further finds it relevant to observe that in the said affidavit filed by the respondent number 5, filed by the Deputy Commissioner, District Commissioner, Kamrup Metro, it is seen that there is a reference to a letter number KRS dash 119/90/5 bracket co dated 23/3/1990. However, the same has not been brought on record. Ms. Yudas, the learned additional senior government advocate, is directed to ensure that the said document is placed before this court on the next date. List the matter again on 15th of December 2023. There's no interim order. Then
Wait, please, Your Lordship. Lordship, in this matter, petitioner has received the amount. My lord, 28,96,995 rupees have been released.
Ms. Jibora,
Lordship,
appearing on behalf of the petitioner, submits that the petitioner has already received the amount of rupees 28,96,995. And as such, the petitioner would not like to further press the instant writ petition. Taking into account the above, the instant writ petition therefore stands closed as infructuous. IA Condivo 1143/2023. In view of the fact that the accompanying writ petition has been closed as infructuous, nothing remains to be decided in the said interlocutory application for which the same also stands closed.
11.
Yes, you filed the affidavit.
Yes. I felt it.
Yes, what do you have to say?
My prayer is that, my lord, they have sanctioned the loan, my lord, 10 lakh, 10 lakh. And thereafter some amount they release, my lord. Thereafter it stopped, my lord. Without,
And you have become an NPA. Have you released any amount? Have you paid any amount back?
No.
As per year? Then what remains?
They have not released full amount, man.
Forget about that. Whatever amount has been paid to you, you are to return. Have you returned it? Then how do you expect that they will give you the entire amount? And more so when in view of their specific stand in the fact that this was wrongly given to you. You had all it was given by the Nongpu branch.
Yeah, no,
When you had no properties, no business, nothing out there at Nongpu.
my lord, they have supplied all document, my lord. But as per my lord, affidavit, my lord, the concerned, my lord, manager has submitted some.
In your favor.
My lord, subsequently they have stated it become NPA, my lord. So after
NPA, you have not paid.
Lord.
How can this go direct? Therefore, the instant petition has been filed by the petitioner, seeking a direction upon the respondents, more particularly upon the respondents, more particularly the respondent number 3, to release the outstanding loan amount and further sought for a direction that the respondent should allow the petitioner to continue the loan account. From the records, it reveals that the branch manager, the respondent number 3, had sanctioned a loan for an amount of rupees 10 lakhs in favor of both the petitioners.
10 lakh each, man.
Yeah.
10 lakh each.
10 lakhs each in favor of both the petitioners. By creating loan account number 880400 ND Pasta 0136 and 880400 ND Pasta 040 on 27/9/2016. From the said loan accounts, the petitioner number 1 withdrew an amount of rupees 3,25,000 and the petitioner number 2 withdrew rupees 3 lakhs. Thereupon, the remaining amount was not allowed to be withdrawn. On the other hand, by communications dated 2/6/2017, it was informed to the petitioner, number 1, that the balance amount payable by him was rupees 3,71,606, and the petitioner number 2 was liable to pay an amount of rupees 3,45,642. It was also informed that their accounts will be inoperative and loan account will be a non-performing asset. It is under such circumstances the instant writ petition has been filed. Be that as it may, the communications dated 2/6/2017 issued to both the petitioners 1 and 2 has not been put to challenge. This court, by an order dated 2012/2017, issued notice and it was further observed that the pendency of the case shall not be a bar for release of the sanctioned loan to both the petitioners. It reveals from the records that the respondents have filed an affidavit in opposition on 9/11/2023. It was further mentioned in the state communication, in the state affidavit, it was duly admitted that the loans of rupees 10 lakhs were duly sanctioned in favor of the petitioners. 10 lakhs each in favor of both the petitioners. However, both the petitioners have not deposited a single installment in their loan account, for which the petitioner number 1's account had become NPA on 29/9/2022, and the petitioner number 2's account was made NPA on
Same date.
full stop. It was further mentioned that the petitioner number 1 did not deposit a single installment in her loan account, and hence the account turned to NPA on 29/9/2021. As regards the petitioner number 2, it was stated that the petitioner number 2 did not regularly deposit the monthly installment of rupees 14,700, and hence that account also became NPA on 29/9/2022. Further to that, it was also mentioned that the then branch manager of Nongpur branch of the respondent number 1 bank had committed gross irregularity while working as the branch head at BO Nongpur from 29/3/2016 to 7/7/2017, for which a charge sheet dated 18/6/2018 was served upon him. Thereupon, the said disciplinary proceedings, so initiated against the then branch manager, ended in imposition of a major penalty of reduction of his pay by 3 stages in the time scale of pay for a period of 2 years, with a further direction that he will not earn increment of pay during the period of such reduction. Further to that, it was also mentioned that this court, that the cause of action which have arisen out for the cause of action for which the instant writ petition has been filed had allegedly accrued within the jurisdiction of the Meghalaya High Court, taking into account that the petitioners sought for loan at the Nongpu branch of the respondent bank, which comes within the jurisdiction of the Meghalaya High Court. This court, upon hearing the learned counsels for the parties and taking into account that the petitioner's accounts have become non-performing assets, comma, the question of issuance of a direction upon the respondent bank to release further amount and to operate the bank account of the petitioner, loan account of the petitioner, does not arise. Accordingly, this court therefore finds no merit in the instant writ petition, for which the instant writ petition stands dismissed.
Alright.
Item 12.
Yes,
I have
which
already-
ex gratia?
I have submitted the deficit court fee matter.
You have given?
Yes, madam, I have already read. And-
Yes. What
and-
are you asking for?
My lord, the dwelling houses and other properties are destroyed, my lord, by setting fire, my lord.
Huh?
Yes, my lord.
Disaster?
Yes, my lord.
What disaster has happened?
Accordingly, my lord, the petitioner submitted application before the respondent with a prayer to pay compensation, but the respondent authority has not paid the same, my lord, till. My lord, the inquiry report, my lord, annexed in the affidavit, my lord, at page 59.
Page
Page 59 of the affidavit.
59.
Yes,
59 of the affidavit.
yes, madam.
Yeah.
Inquiry report. And the police report annexed, my lord, at page 57 of the affidavit. Here the petitioner, my lord, 1 to 4. Serial number 1 to 4 are the petitioner.
Yes. So total loss is 1,40,000.
No, my lord.
Given here, total loss of property is approximately 1,40,000.
Personalized, my lord.
Huh?
The loss was mentioned personalized.
What per
Yes, my lord.
approximately? Where person wise?
My lord,
Total loss of property is approximately 1,40,000.
no. My lord, comes to page 34.
Huh?
And
Page
yes, my lord. Page 34 of the report, my lord.
yes.
Mostly 168.
No, this is your Ejahar. They
Yes.
found on inquiry to be 1,40,000 total. Now, how much are you asking for?
I am afraid for my lord, as per scheme, my lord.
How much are you asking for?
My lord, as per scheme, my lord, per house is 95,000.
losses total for 4 houses is 1,40,000. And you are asking 4 lakhs. Why?
No, my lord, per house, my lord, in the police report also mentioned, my lord, the amount,
Amount is total is mentioned.
not total, my lord, personal is mentioned.
Where is it?
My lord, police report in my description, my lord.
Yeah, for the type of it.
Page 36, my lord, in the report. Page 36, my lord. And this police,
Where, under which is the scheme under which you are entitled to?
scheme, my lord,
Page 12.
page 12, my lord. And the quantum, my lord, mentioned, page 31.
Page.
Page 31.
Who
Housing, my lord.
pays this amount?
Kacha house, 95,100 per house.
Kacha house.
Yes, my lord. Housing, serial number 2, my lord, Kacha house, rupees 95,100 per Kacha house. And in the inquiry report, my lord, the house is mentioned, my lord, in the affidavit, my lord, case 59.
Page?
Case 59, my lord. Mostly, my lord, 2. In the right, my lord, 2. Kumarali, 2. Saharali, 2.
What?
Yes, my lord, in the type of house damage. Then, my lord, fully damaged, destroyed. Column
Page
number.
59. What is this page 59? Yes.
This is the inquiry report. Case 59.
So against each house you are entitled to 95,000.
95,100. 95,100.
Each house.
Each house.
95, that is, you are entitled to Mustab Ali, he will get for 1,98,90,000.
Yes, 95 on 90. 1,90,000.
Well, I have written to the department, and department has called a report from the deputy commissioner. Now, deputy commissioner informed that for releasing the rehabilitation grant, the report of the fire and emergency service is required. That is not available. That is not being received. For which this
Who submits this?
this is the
Who gets this fire and emergency service?
that they need to submit a report regarding the fire incident that they have not furnished.
No, is it for the petitioner to submit or who? Who is going to submit that?
Fire and RG. It says Office of the Fire and ESS Vilasipara.
So the fire department has given against him.
Yes, there is no record is available.
My lord, come to page 40 of my report. And particular page 41, my lord. In the application itself, my lord, the fire brigade report is forwarded to the SDO civil village section. As per police report, set fire on so and so. at the applicant's house and burned property, but no information sent to this office due to to this fire brigade vehicle at the place of fire.
Understood whether they have received this communication.
Yes, my lord.
How do we
And-
know?
Yes, my lord. In the page 40 on bottom, my lord, receipt number is there also, my lord. Receipt number is there. And my lord, the WT message, my lord, at least 50 of the
Who appears for the fire?
village Barawan.
Huh? Fire, you have not made a party.
No, my lord. Fire.
Fire is creating problem now.
And my lord, page 60 of the affidavit, my lord, here it is mentioned that, my lord, submission of the original fire report and police report along with your proposal, the sanction of the so-and-so. My lord, this is the report letter issued by the deputy commissioner to the circle officer. Page 60 of the affidavit. my lord.
Mr. A. Bhattacharjee, the counsel appearing on behalf of the Revenue Department has placed an instruction dated 21/9/2023 issued by the Additional District Commissioner Dhubri, wherein it has been mentioned that the sub-officer Vilasipara FNESS District Dhubri had submitted a report wherein it was mentioned that there was no record of such incident found to have been available in the office of the Fire and ESS Vilasipara. Mr. M. Hussain, appearing on behalf of the petitioner, submit that the representation of the petitioner claiming the amount of compensation was through the
HDSP bill. Page 40 onward, my lord.
was to the officer in charge Fire Brigade Vilasipara.
Yes.
He therefore submits that the said report, as mentioned in the communication dated 21/9/2023, could not have been issued, that the said fire that there was no report of the incident. Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the revenues, shall obtain necessary instructions in that regard. The instructions so placed before this court is kept on record and marked with the letter X. List the matter again on 13th of December 2023.
Obliged.
Map visible. As for the last order, my lord, the state was asked to file the affidavit, but they have filed yesterday, my lord. So I need to, my lord, reply it, my.
The Mr. J.L. Bordhuia, the learned counsel appearing on behalf of the petitioner, submits that pursuant to the order dated 10/11/2023, the additional affidavit filed by the
That's one of
was filed by the Superintendent of Police, Kamrup, Aminga, bringing on record the report of the Hado PS case number 212/2018. He submits that he requires to obtain necessary instruction in that regard and seeks for an accommodation. List the matter again on 13th of December 2023.
Affidavit by the respondent number 5 may not be available in the record.
It is
I
there.
have called.
It is there.
Obliged.
14 and 15.
Okay, here in terms of your notice order that is 16/10/2023. They're supposed to file affidavit by 6th of this month. They file on 14th month. I required opportunity to file reply to their affidavit.
Who?
I am for the petitioner.
Who has filed the affidavit? Respondent number 2.
Respondent number 2 has filed. It is stated that additional affidavit, but that is affidavit in opposition.
What is your case?
I am agreeing against that reallotment of that soft in favor of the other. So I required opportunity to file and reply to this affidavit. I received it only on 14th, 2 weeks for the time.
It reveals from the records that on 14/11/2023, the respondent number 2 had filed an affidavit in opposition. The learned counsel appearing on behalf of the petitioner seeks for an accommodation of 2 weeks for filing a reply. This the matter again on 11th of December 2023. In the meantime, the said affidavit will be filed.
File. Right.
Yes, Karim.
We have filed one IA for substitution of the private respondent, and your lordship directed them to bring instructions whether.
My lord, as per the order of this honorable court, my lord, date was fixed on 13th September 2022, my lord, for joint verification, my lord.
Yes.
But my lord, neither the petitioner nor the respondent has contacted with the office, my lord.
No?
Date was fixed on 13th September 2022, my lord, for joint verification, my lord.
What is the case about? There was a direction to file some report.
My lord. But my lord,
Date of site verification will be intimated by the office to the petitioner as well the neighbor's priority. Yeah,
My
what
lord,
is that?
my lord, the verification could not be done, my lord, because the petition, neither the petitioner
One
nor.
notice was served to the petitioner, that is
With
not.
reference to the subject, I would like to inform you that as per the order dated demand, a joint verification had to be carried out on 13th of September demand by the concerned demand. The plot of land and to submit the report urgently regarding the drainage system at plot number. Help with my team at report was in this context. It reported that neither Dilip Sharma nor the chief engineer, PWD, chief engineer DMD or the deputy contacted the undersigned till 40. Then it is at your instance this verification was to be carried out. You only made a submission on 15/6/2022 that give me some opportunity for filing the report. Here it says, Mr. P. Nayak, the learned counsel for respondent number 3, 4, and 6, is permitted to file a report by the concerned officers by way of an affidavit after making a proper field verification of the site. He prays for 3 weeks' time.
My lord,
Why haven't you done that?
my lord, kindly peruse, order dated 15/6/2022, my lord.
That is what I am reading.
My lord, the
I'm
date
not
of,
reading anything else.
my lord, there is a last line, my lord, the date of site verification will be intimated by the officer to the petitioner as well as the neighbors prior to the undertaking. The
The
site
verification now.
My lord, they have intimated, my lord, but no, not the petitioner nor the respondent has contacted with the office, my lord. And date and time has already been fixed, my lord. 13 September 2022 at 12:30 PM by the concerned officer.
Hmm.
As per my information, no notice was served to the petitioner and no
Then?
information.
For that matter, I may be allowed to bring the records that will reveal. I may be allowed to bring the record matter.
Unnecessary. Why should I do all this thing? What is the case here?
Lordship, the impugn
And not be set aside in quashing the impugn notices by which the petitioners have been directed to remove the violation and as to why are read in the main members of the who has directed you annexes 6 and 6A?
your medical
6A,
GMC.
6A and 6A. Dilip, the waste coming from your pipe is seen overflowing in the road causing health hazard. Same. Who is Dipen Sharma?
Lordship, petitioner, Dilip Sharma and Dipen Sharma are brothers. Lordship.
Waste is coming from your pipe.
Yes, Lordship, some pipe, they have Lordship managed the pipe to Lordship produce that outlet this waste product Lordship behind the side of the road Lordship, not over the road as per information.
Hmm.
So when this notice were served Lordship, we filed this petition and during while it being.
There was a stay.
Yes, Lordship.
Thank goodness. Yes, Mr. Nayak. Come to the help of your junior.
After the last date.
What is
Lordship,
this?
when
If it is a health hazard, how can this court state?
Lordship,
You need to carry out if it is there or not. You submit a report. Forget about who is there or not.
Lord.
As to what is the state of affairs. And if it is so, if there is something, take some action. You have a power to take action.
Yes.
What power do you have?
Lordship, if it is there, Lordship, we can remove that.
Remove it. If it is coming out from there.
Lord.
Or give them a
Practice
solution.
are very clear.
Give them a solution. What can be done? You can't have the waste coming on the road. It's not possible. That's a health hazard. There's no quarrel with that proposition. What has been stated in the annexes 6A and 6B is absolutely right.
Lordship.
But the fact as to whether it has happened or not is subject to a verification. And why do you need if the petitioner is there or not?
Lordship.
If you find out anything, yes, there is a health hazard, stop it. Can't go on. You can't give a stay to that effect. What is the stay or is there any stay?
In fact, Lord, we were Lordship.
Pendency will not be a bar to the respondent, more particularly to take up the matter with the respondent for removing the blackage from the drain. That is it. There shall be a stay to the notice. How can there be a stay?
There is a provision for construction of cattle bridge, Lordship. That was not carried out, Lordship.
Huh?
Cattle bridge. There is a provision for construction of cattle bridge, to Lordship, to keep the drainage for the passing of the drainage, Lordship.
You, Mr. Nayak, you do one thing. Get your instruction to the effect. What can be done out here? Just, you can't stop them also. For the egress of the waste, something has to be, somewhere it has to go. It can't lie inside their house. The waste has to go. But what is the solution? Provide us that. Either it has to be put in the drain, or do you have a drain or not? Something has to be there. It even can't go to the road also. Absolutely. It will be a health hazard. But under such circumstances, what is the solution? Give us the solution to the effect, on the basis of which I can give you the green signal. You go ahead then. I think that is a fair to both of you. Because they also can't have the waste inside their house. It has to go somewhere. So how do you take care of that?
Lordship. Lordship, here one notice was issued to the petitioner also, Lordship.
Okay, let us not go by all these things. Let us make the thing simple. Here there is a waste which is going. So what is the solution? What can be done? So that we can direct the petitioner to do it.
Earlier there was a PIL, Lordship. That also I have annexed along with this petition, Lordship. Page 14, Lordship.
Okay.
Your plot is 79.
No, Lord. 79 is private response. Page 80 is the finding.
To our private response.
It is in Kharguli.
Yes.
And you are in government land,
No, Lord.
your private land.
Yeah, our private sector. Plot number 82 is occupied by private respondent, and 79, when the same problem arises, they filed a PIL. 79, some other particular.
So there is a discharge of the waste
Lord.
from your plot.
Lord.
There's no quarrel with that.
Lordship.
But
That we have
what is the
managed-
solution?
Lord.
Is the question.
Solution is, Lordship, there is a provision for cattle bridge, Lordship, if the
Cattle bridge.
Yes.
What is
Lordship,
that?
it is within the road, Lordship. A cattle
it's a
bridge is
culvert
constructed
kind
by
of
the culvert,
thing.
Ah.
Lordship, constructed by the PWD department, Lordship. And that
But he appears for PWD also. He can.
Sorry.
PWD also. Yes, so he can. And then
is the private respondent disturbed as per our information, Lordship, in construction of that cattle bridge, Lordship. Thereafter, the
who is
neighboring
private respondent? You're disturbing in the construction of the cattle bridge.
We have not received the lordship petition yet.
A copy of the petition you have not received.
Yes.
I have, Lordship, I have called him and asked him whether he will receive. He said me, Lordship, after contacting my clients, I will inform. Thereafter,
No,
he did
I
not
have-
inform me, Lordship.
I have called.
So I have an extra copy with me, Lordship,
Ah,
to serve
give it
him.
in.
Today morning also he called me. Lordship.
Okay. The instant petition has been filed challenging the notices dated 26/7/2018 issued to both the petitioners. The individual notices dated 26/7/2018 issued to both the petitioners, wherein there was a direction by the senior medical officer, Guwahati Municipal Corporation, to remove the violation within 7 days of the receipt of the named notice, failing which action would be taken. The violation which was alleged therein is that the waste was coming from the pipe of the petitioner. Waste coming from the pipe of the petitioner were overflowing in the road, causing health hazard. It reveals from the records that there is a stay to the said notices. Be that as it may, taking into account that there is taking into account the question of a health hazard, which is health hazard to the public in general, this court is of the opinion that the commissioner, who can give you an idea? The commissioner,
GMC law.
the commissioner, GMC, ought to apprise this court as to how the said health hazard, how the said waste coming from the pipe of the petitioners could be, how the problem as regards the waste coming from the pipes of the petitioners could be resolved. In that regard, this court fixes the matter again on 18th of December 2023. On the said date, the Mr. P. Naik shall ensure that the report is received from the commissioner GMC as to what steps can be taken to stop the public health hazard. List according.
Lord, will allow subsidy
Who died?
the private responsibility.
Who
We
died?
have filed this IA civil 3367/2020.
Private respondent died. Respondent Sarat Kumar Chandra Kumar. He is survived by
Lord, Para 1. Mrs. Bobita Kumar, Mrinal Kumar, Anupam.
the instant application has been filed by the petitioner seeking substitution of the legal heir, legal representatives of the respondent number 7, who expired on 8/5/2021. It has been mentioned that the petitioners were not aware about the death of the private respondent number 7, and as such could not file the said application immediately. However, on coming to learn about the death of the private respondent number 7 on 8/5/2021, and taking into account and finding out the legal representatives of the private respondent number 7, the instant application has been filed. This court, upon hearing the learned counsels, is of the opinion that the right to sue against the private respondent number, against the legal representatives of the private respondent number 7 continues in spite of the death of the private respondent number 7. Accordingly, this court therefore substitutes the
Para 1.
opposite parties number 7-1, 7-2, and 7-3 against the private respondent number 7 and erase them as respondent numbers 7-1, 7-2, and 7-3. The petitioner shall file a memo of parties by 22nd of November 2023 before the registry of this court. And on the basis of the same memo of parties as well as the instant order, the registry shall make necessary correction of the records, as well as also update the same in the cause title. He আগৰ order to the আছে নহয়, he আগৰ order to Mr. So-and-so. নামটো কি?
Your name. Pintu Bor.
Who was appearing on earlier on behalf of the respondent number 7, submits that he has instructions to appear on behalf of the newly arrayed respondent number 7-1, 7-2, and 7-3. And full stop. During the course of hearing, the learned counsel appearing on the behalf of the petitioner have also served a copy of the petition to Mr. So-and-so. The private respondent number 7-1, 7-2, and 7-3 would be at liberty to file their reply on or before the next date. তাৰ পিছত সেইখিনি দি দিম হা তাৰ পিছত মই প্ৰথমতে এইখিনি দি তাৰ পিছত
May, my lord, the petitioner's name, my lord, enlisted in the, my lord.
Yes, Mindranath, why haven't you paid?
Like what the instruction, my lord.
you are not enlisted under the socio-economic and caste census. You have to get yourself enlisted and then apply. But however, 7 of the petitioners have already received out of the 9, 1,30,000. You know that. They don't inform you. Don't worry. We'll record. Who have received the 7?
The 7 would be the remaining. I don't have a copy of the rate prediction, my lord. Except for, my lord, the Boichal Burman and Hedester Burman.
They have not received.
They have not.
On
What's the name?
account of his name is not there in SEC. And the 8, his name is there, but the problem is his father's name is not matching. As regards petition number 8, Hedester Burman. Others have already received the hope. The incident petition has been filed by the petitioners who are 9 in number, being aggrieved by the inaction on the part of the respondent authorities in not allotting or releasing the assistance under the Pradhan Mantri Awas Yojana Gramin houses. Full stop. Today, when the matter has been listed, Mr. N.K. Devnath, appearing on behalf of the respondent, PNRD department submits that except respondent number 6 and 8, all the petitioners have already received their entitlement of an amount of rupees 1,30,000, and their houses have been duly sanctioned and completed. As regards to respondent number 6, petitioner number 6, his name is not present at the he is not enlisted in the socio-economic and caste census, bracket SECC, bracket close, 2011, and Awas Plus wait list, for which the petitioner number 6 is not eligible. As regards to petitioner number 8, his name is though there in the wait list of SECC and Awas Plus, but his father name is not matching.
And perhaps, my lord, it is matching, my lord. You see the memo part is written Hedester Burman, son of Radeshwar Burman. At page 5, my lord, of the rate prediction.
Taking into account that the petitioners number, that all the petitioners except the petition number 6 and 8 have duly received their entitlement, nothing survives to be decided in respect to their entitlement. However, as regards to respondent number 6 and 8, petition number 6 and 8, it is the opinion of this court that as the guidelines require that their names, they have to be enlisted in the SECC and Awas Plus wait list. The said petitioners would be at liberty. The petition number 6 would be at liberty to approach the video Golokganj Development Block seeking his enlistment in the wait list. As regards to petitioner number A, this court grants the liberty to the said petitioner to approach the BDO, Golokganj Development Circle, and produce the necessary documents and clarify before the said authority in respect to the mismatching of his name along with his father. With above the instant petition, therefore stands disposed. The instructions so placed by Mr. N.K. Debnath is kept on record and marked with the letter X. 18. The video Golokganj shall do the needful upon the petitioners approaching as per the guidelines of the PMAG Niki, Pradhan Mantri Awas Yojana Gramin. Yes, madam.
Kindly take this matter along with the IA, the statement of
IA file.
filed on 18/11.
Copies are lordship not listed.
Okay. Ms. So-and-so appearing on behalf of the petitioner submits that an interlocutory application has been filed. However, the said interlocutory application is not on record. The registry shall list the matter on 13th of December along with the said interlocutory application. What is the affidavit?
In this matter, my lord, affidavit filed by the circle officer annexing the running report, my lord.
For the records available. None appears for the petitioner. None appears on behalf of the petitioner on call. It further reveals that the respondent number 4, that is the circle officer, Dispur Revenue Circle, had filed an affidavit on 17/11/2023 stating inter alia that a report of late Noor Islam of a drowning incident dated 4/8/2018 was submitted to the Deputy Commissioner Kamrup Metro by the then Circle Officer Dispur Revenue Circle. The said report had been enclosed as Annexure Roman 1 to the said affidavit. In the remarks column of the said drowning report, it has been mentioned that the minor boy had fallen into the Bahini River at Pipo bus stand near Reliance Train to Rukmini while he was picking up waste bottles in the river. Under such circumstances, the question arises as to whether the petitioner would be entitled to receive the compensation in terms with the ex gratia, in terms with the scheme. In terms with the scheme under the equation, in terms with the scheme from the State Disaster Response Fund, public National Disaster Response Fund. So, taking into account that the petitioner is not represented today, this court fixes the matter again on 20th of December 2023. Madam, you address this court as to whether they are entitled to, because it's a case of drowning,
Yes.
whether it
In
took
fact,
place on its own or how.
My obliged.
Yes, madam.
Yes, your lordship. My lord, here the petitioner is a registered firm, my lord. The firm was, my lord, work order was issued in favor of the firm. That is, work order is page 32 and 33, my lord. Three numbers of work, my lord. Construction of video quarters for AP at Hailakandi Development Block, construction of grade 3 quarter, and construction of grade 4 quarter. Other works have already been
Who are you?
completed. The petitioner, my lord.
Understood.
He is the my lord, registered firm, construction firm, my lord.
Then,
My lord, the two works have already been completed, and my lord, and bill was also released.
no,
Only
what
in
is your
respect of-
relationship of getting these rates?
My lord, rates, my lord. My lord, here the construction work could not be conducted. One construction work, that is construction of videos quarter, could not be, my lord, it could not even be started because the video refused to vacate the construction site. So that is why, my lord, the petitioner could not start that work on construction of the video quarter, my lord. So the petitioner filed a writ petition before, my lord, initially he submitted several representations for before the deputy commissioner for clearing the construction site. That was not done, so he approached this honorable court by filing a writ petition. In the writ petition, there was a direction, my lord, to vacate the my lord site, my lord. That is at page 30, my lord.
38. The order is 38, begins at page 38.
Page 38, relevant portion, page 39, my lord.
Then,
His prayer was regarding clearing the site and as well as the enhancement of the rate, my lord, because
rate was not given.
no, my lord.
Rate was left with him.
Rate, my lord.
Thursday.
Yes,
It was
my lord.
made. Now, what do you want? You want the enhancement of the rate?
Yes, my lord.
How would this court decide that?
No,
Tell
my
me.
lord. For enhancement of rate, there was a direction to approach the deputy commissioner.
So what?
Accordingly,
How much rate? How he is entitled to? How can this court go get it?
No, my lord. It is the my lord, deputy commissioner. So, my lord, that deputy commissioner representation was submitted before the deputy commissioner, and he was asked to submit his rate, my lord. So, accordingly, he submitted his estimate. So, subsequently, there was a meeting with the deputy commissioner as well as the my lord panchayat department, my lord, and they also called the petitioner there in the meeting, my lord. Then there it was decided, my lord, they have, my lord, the petitioners, the rate quoted by the petitioner was 8,99,324, and they have deducted, my lord, more than 30%. Your lordship may kindly see page 51. First they made deduction and made it 7,60,913. Then again they made calculation and they deducted and made 5,07,380, my lord. So, my lord, so it is not possible for the petitioner even to complete the work, my lord, on this rate, because
Then what do you want?
Initially also he quoted less.
No, what do you want
10%.
this court should do?
My lord,
This court should
direction to
increase it.
take a fresh hearing, my lord, on the
Absolutely
estimate.
no. That is your lookout. If they don't do it, file a civil suit or do for breach of the contract. Do something. How can this court decide? And why should this court decide between you and the deputy commissioner? What they do rightly or wrongly, that is their lookout. Court can't give all this direction.
Because the work orders were.
The problem arises because of that. The coordinate bench have already said that this court under 226 cannot. But out of sympathy, gave you an opportunity of approaching them.
Yes, ma'am.
And this sympathy, now because of this sympathy, this matter is pending.
That is there, my lord, but my lord, the work order.
But madam, you know,
by the chief
this
executive
court doesn't have that
officer.
sympathy. No sympathy. Because this, under no circumstances, this writ court can exercise any jurisdiction here. If they're done it wrongly, rightly, you go before you have a civil suit, file civil suit, or you don't do it. That is your lookout. They have given some price escalation also, 1,93,000.
Yes,
Difference of amount as per the schedule 2013 and AR. This minus this is so and so.
This is with regard to
80% of the so and so is demand. Previous agreement rate of 5 lakhs demand. Price escalation this. Now they have willing to pay you 7,63,000. You say that you are entitled to.
Yes, my lord. Petition is was agreed, my lord, for 7,60,000. But now they have made again they have made deductions and made it 5,07,380. Next page,
Difference
page
between
52,
so
my
and
lord.
so price
This is with regard to a
escalation
different-
demand, previous rate. Yeah, this is different.
Yes, ma'am, different.
This is different because
DP secretary.
madam,
My lord, in that case,
no, madam, kindly see. The first at page 51 is for a plinth area of 5520 square meters. The second is a plinth area of 37.64 square meters. Then these are two different things.
Then 7,60,000 is, my lord, the petitioner has already agreed, my lord.
You have taken that
But maybe there is my lord, calculation, my lord,
because this is a different one. Then what to do?
so far as this amount petitioner agrees, my lord.
Very well.
7 lakh.
Go before the petitioner. Respond. Get the money. And have you done anything? This is a own matter.
Yes, ma'am.
2019, 4 years a ban.
In fact, before filing of this petition, my lord, the site was already handed over to them, but they had not commenced the work.
And only because of this, my lord.
This is absolutely within the realm of the contract. This court under 226 cannot. Making it very. We dismiss it on that.
In that case, I may be allowed to withdraw, my lord, and defer it to approve the proper court.
That is what I am saying. No, if I dismiss it on the ground of jurisdiction, then only you get your limitation. If you withdraw, you don't get the limitation. Let me dismiss it. On the ground of jurisdiction that this court cannot do under 226. However, the petitioner shall be at liberty. That is the only way out. Yes. The instant the petition has been filed by the petitioner, being agreed by the non-consideration of the petitioner's representation for enhancement of the rates. It reveals from the records that the petitioner was allotted a contract for construction of BOD, BDO oblique EO quarter for 80 at Hailakandi Development Block. Number 2, construction of grade 3 quarter for 80 at Hailakandi Development Block. And number 3, construction of grade 4 quarter for 80 at South Hailakandi Development Block. The petitioner was issued a letter of acceptance on 22/8/2014. Thereupon, the notice to proceed with the work was issued on 4th of September 2014. However, the petitioner could not start with the construction of the BDO oblique EO quarter for 80 at Hailakandi. As there was no land clearance the petitioner duly approached the respondent authorities, including the Deputy Commissioner Hailakandi, for land clearance. However, as the land clearance was not granted, and there was also a request for enhancement of the rate, which was also not considered, the petitioner approached this court by filing a writ petition, that is WPC number 6130/2017. By an order dated 22/2/2019, the respondents 22/2/2019, this court, taking into account the that there was no opposition to the prayer for handing over the site to the petitioner, so that the petitioner is in a position to complete the work. Appropriate directions were issued for vacating the existing quarters within 4 weeks from the date of the said order, after giving due notice. However, as regards the second prayer for enhancement of the rate, it was the opinion of this court that such prayer, such a relief cannot be considered under Article 2 to 6 of the Constitution. And the petitioner was given the liberty to approach the respondent authorities seeking enhancement of the price on account of escalation, on account of price escalation. The petitioner, on the basis of the said liberty so granted, approached the respondent authorities and in the minutes of a meeting held on 26/3/2019, it was observed that the petitioner would be entitled to a total amount of rupees 7,60913 in respect of the BDO/EO quarter bracket Assam type building having a plinth area of 55.20 square meter and rupees 5,12,204 in respect of AP/GP secretary grade 3 quarter bracket Assam type building plinth area that equals to 337.64 square meters. The petitioner being aggrieved by the amount of compensation, amount of price escalation, being aggrieved by the price escalation so granted, has approached this court by filing the instant writ petition. This court, having duly heard the learned counsels for the parties, is of the opinion that the same aspect as regards the price escalation comes absolutely within the realm of the contract between the petitioner as well as the respondent authorities. And this court, in exercise of the jurisdiction under Article 2 to 6 of the Constitution, would not be in a position to adjudicate the same. Under such circumstances, this court cannot issue the reliefs which have been sought. This court ought not issue the reliefs as has been sought for in the instant writ petition. Be that as it may, for which the instant writ petition stands dismissed on the ground dismissed. Be that as it may, the dismissal of the instant writ petition shall not preclude and prejudice the petitioner to approach the appropriate forum, if so advised, and the period during which the instant writ petition have been pending, that is from 30/7/2019 till today, shall be excluded while computing any period of limitation. I don't give any. Did I put her name? You give your name, everything will be put in golden letters. 51. Ankita will. Which is? Mr. B. Chakraborty, give your name in that slip. They will put it. Yes, Mr. N.K. Kolita.
The petitioner was occupied, grandfather of the since the day of grandfather, since 1965. Petitioner has been occupying a land measuring
petitioner or petitioners?
No, earlier petitioner, he died. Thereafter, his wife came in.
How many wife? Petitioner died and how many?
Vasanto Das was.
And who are these people? Respond number 4.
No, those are
respondents.
Petition was filed by some respondent.
Okay. Now what do they want? What do you want? You want a settlement of the land. Setting aside the impugn eviction notice dated so and so, issued by respondent number 3, and a writ of mandamus directing as a more particular response to dispose of the representation dated so and so, and the application of settlement dated demand as well as the representation as well. Okay, yes. Where is your application?
Earlier,
application. Where is your application?
Application for settlement, that is, at NXR 8,
Where is 27/1/2020?
27/4, it should have been 27/4.
Okay, where? With reference to regarding eviction, with reference to you are hereby informed that you are illegally occupying land covered by tag number 386 old under so and so, with reference to here.
Case 24.
Yes. Where is the original one?
Hello?
Where is the original one? Yes, let us see original one. That is also 27/1. Why you are saying 27/4?
No, representation 27.
I'm not on that. The notice you are challenging is 27/1.
Yes, my lord. 27-1, my lord.
Otul Chandra Das. What is the name of your petitioner?
Basanta Das, my lord.
Vakanto Das is where? Vakanto Das.
Yes.
Bharatia.
My lord, in the earlier occasion, my lord, when earlier eviction notice was issued in the on my lord 12/4/2017, my lord, at that time, my lord, 2 tenants were there, my lord. Because my lord, financially, my lord.
You are a tenant?
No, my lord, I am the owner, my lord. I am possessor, my lord.
You are a possessor of government land.
Yes.
Okay, then?
My lord, at that time, there was 2 tenants, my lord, under me, my lord.
Hmm.
And thereafter, my lord, when my lord, that eviction notice was issued, this honorable court, my lord, was approached by the.
How much land you are asking?
My lord, 15 lesser now, my lord. Only 15 lesser.
Yes.
Lordship.
What type of notice is this? How can you give a notice without a schedule?
Lordship.
Huh? It's not done.
But if your lordship comes to our affidavit,
Understood, but what type of notice is this?
lordship, it should be. The schedule should be there.
Schedule without the schedule, yes. What is your affidavit?
Affidavit, your lordship may come to page 40. Running page 40, that is the affidavit filed by the respondent number 2, Deputy Commissioner.
Along with others.
Paragraph 4.
Paragraph 4.
Yes, that with regard to the environment. Then
You rented rooms also.
Well,
You rented rooms also.
that is what I am submitting, my lord. Earlier, my lord, 1 person was there.
I'm coming at 2. Get your instruction, whatever.
where is lordship? PW.
After death of the, my lord, present petitioner husband, my lord, the wife again submitted another application under Bosandhara 2.0, my lord. I have annexed the, my lord, that application in the reply affidavit.
The instant application has been filed. The instant writ petition has been filed, challenging the impugned eviction notice dated 27/1/2020, issued by the respondent number 3, and further seeking a direction upon the respondent authorities to dispose of the representation dated 27/4/2017, as well as the application for settlement dated 30/3/2019 and the representation that dated 3/2/2020. This court had duly perused the materials on record, as well as the impugned notice dated 27/1/2020, whereby it has been alleged that the petitioner is in occupation of government land covered by DAG number 386 new /411 old under village Maligaon of Jalukbari Moja. This court have also taken note of the affidavit filed by the respondent number respondent number 2, wherein it has been mentioned that land measuring 10.59 R have been recorded as government DAG number 411 old 386 new of Maligaon under Jalukbari Moja, and the said land is recorded as Aliban PWD. It was further mentioned that during the verification, it was seen that the petitioner is residing in a part of the aforesaid DAG number 386 in a tin roof constructed thereupon. Further to that, the petitioner had also rented 2 rooms where the timber shop is running. It has been denied, though there has been an allegation to the effect that the eviction proceedings have been initiated at the behest of a builder, namely Ratul Prasad Sharma, but the same has been duly denied too in the affidavit filed by the respondent number 2. This court have also taken note of the application which was filed by the petitioner, the original petitioner. For settlement of the said land under their possession. And also that the said application was not disposed of. It is further seen that upon the death of the original petitioner, the substituted petitioner, that is his wife, that is the wife of the original petitioner, had also submitted an application in terms with the Vasundhara 2.0 scheme. And in that regard, the said application was duly acknowledged as far back as on 22/3/2023. And in the acknowledgement, it was mentioned that as to whether the application would be accepted or not shall be duly intimated within a period of 300 days. This court, upon taking into account that there is an application filed by the substituted petitioner seeking settlement of the land from where the petitioner has been sought to be, from where the petitioners were issued the eviction notice, is of the opinion that till the application of the petitioner is not disposed of, application bearing acknowledgement number RTPS/SK/CSL/2023/124817 dated 22/3/2023 is not disposed of. The petitioners ought not to be, petitioner should not be evicted from the said land. Accordingly, this court therefore disposes of the incident with petition, thereby directing the respondent authorities to duly consider as to whether the petitioner would be entitled to the settlement of the land for which the application has been duly filed by the substituted petitioner, and as per the land policy of 2019, and if it is the opinion of the respondent authorities that the petitioner is not entitled to the settlement, then the petitioner be duly informed as the reasons for the same. It is only upon due intimation to the petitioner the respondent authority shall be at liberty to take appropriate action for eviction of the petitioner. With the above the instant petition stands.
My lord, may I please submit little observation method? Because I'm for private respondent method.
Who are you?
I'm for respondent of 4 to 14 method.
Yeah.
So he has technically in the first petition he said that the land is of 24 feet width. But still now, my lord, he is a poor fellow, my lord. We have settled given him a proposition that we'll give equivalent portion of land outskirts of Guwahati if he goes for settlement. So that if
then it becomes between you and them.
Yes, my lord, his observation.
But the
may be-
fact is, he's in occupation of government land.
Yes, my lord.
What business you have?
But they have blocked the entire passage of my apartment.
So
and
what?
we have,
Who are you?
so we are,
It is not, it is for the government.
yes, my lord.
If you make that submission, I will hold that it is absolutely illegal. You enter into an agreement with him, it's a different aspect. I'm not on that. That is a different aspect. But here is a case that when his application for settlement is pending, he should not be evicted. So once they reject the application, yes, for good reasons, they can very well reject if it doesn't fall, because it is a PWD Aliban, which means the road of the PWD. For that, they may not give him a settlement. So these aspects of the matter, they will consider. So they will consider for good reasons. Era line लिख दी, huh? Be that as it may, before concluding, this court, however, finds it relevant to take note of the submission of the learned counsel appearing on behalf of the private respondents, who submits that the petitioner's occupation over the government land, which is specifically reserved for PWD, road, have duly affected the ingress and egress of the occupants of the apartment, which the respondent number ingress and egress of the private respondents. It is the opinion of this court that same aspect of the matter be duly taken note of by the respondent authorities while considering the application of the petition.
Hello, bless.
এখন দিবে না নাই দাদা মই দিম
আগতকে নেকি আপোনাক মোক এইটো
Yes, Mr. Rajgupta, what is your claim in your petition?
actually these persons were allotted the quarter and they could not avail it. Subsequently, we approved before this court. And this
You were allotted the quarter for what?
under quarter means on a house.
By?
Under urban elevation of poverty to similar. But that we could not avail it. Thereafter, we approved before the Guwahati Municipal Corporation. And they hold an inquiry. And in that inquiry report, they published a report in our paper. But despite that, we could not avail it. Therefore, we approved before this honorable court. And this honorable court also passed an order to consider our case. And
thereafter, again we approved before the social Securitas Commission. And the Securitas Commissioner, referred this matter to the Deputy Commissioner for allotting some land to us, and some initiative was taken. And that stage, we came before your lordship.
This court directed, what considering the above, GMC is directed to take into account the inquiry report given by the, he must frame a fair criteria for allotment of available quarters to the eligible supply commercial. Thereafter, allotment should be made on a fair and transparent basis in accordance with the population yard. Allotment of land for accommodation of the region will also be considered on merit by the commissioners when then
we submitted representation before the Deputy Commissioner Kamrup. That is at page 39.
Page
39.
But the direction was to the GMC.
Actually, what happened?
There was no direction to the Deputy Commissioner.
Actually, what happened here, my lord, the government of India undertook a project to.
I know that matter.
Yes.
Yes.
Is that matter?
Mm.
Pursuant to that, some quarters were allotted to us, but we could not avail.
You not only availed, you did not, you ran away.
Yeah.
And you also did not pay any, so the quarters were subject to pay some payment, allotment fees or something to that effect, if I'm not wrong.
No, in that case, that is the case. But here
Here
it is not
also?
the case. That is not the case here.
You were allotted free of cost.
No, we were allotted, this allotment orders are here.
Where?
Your lordship will find at page 16 and 17.
That is what number 2. The allotee shall pay an amount of ₹500 of the quarter, including maintenance and other, and shall be deposited in the first week of each calendar month.
But
So
the allotment, when these were allotted, some people of our locality, they entered in our room, and we have been driven away from that locality. Then we approved before the police authority, but we could not get any relief. Then we approved before the municipal corporation. Municipal corporation also held an inquiry, and the inquiry officer has submitted a report in our favor. Thereafter, we approved before this honorable court. Then honorable court has passed an order that effect.
I had only directed the GMC. The Honorable Court's order, this court's order is only to the GMC. Page 38.
Here.
Yes, then
Inquiry report.
not to the Deputy Commissioner. The pending representation stated of the petitioners in WPC for allotment of land for accommodation
number?
of the Harijan should also be considered on merit by the Commissioner GMC. What is the Deputy Commissioner going to do?
As it was not, no accommodation was allotted to us, my lord, then we approved before the Securitas Commission. Then they referred this matter to the Deputy Commissioner. And the Deputy Commissioner, pursuant to that letter, made an endeavor.
Because the land which the Deputy Commissioner is saying, mentioning is a land which now presently is in the area of the WRD.
Water resource.
And
the GRP also.
But Mr. Sharma, you have a copy of this?
Lordship, I've seen. I've seen.
The additional Deputy District Commissioner Kamrup doesn't know how to write English.
Lordship.
Does not know what is the spelling.
Lordship.
Fair means fail.
Lordship. Lordship. I've seen.
Instead of right, it is written as ride.
Lordship.
May I have a copy?
He wants a copy of this.
Why? You want to have a laugh?
No.
Otherwise, what is there? There's nothing else. Means the spellings and all.
Spelling is
It's
not a
laughable.
factor.
No, not only that. Kindly see. Let me read it as they have mentioned. As the quarters allotted to the petitioners by the Guwahati Minister were subject to payment of rent, vested RID, if any, occurred to the petitioners, further allotment of quarters for only be dealt by the Guwahati Municipal Corporation. What is this English?
Another one.
The office tried its best to seek status of the vacant land as pleaded by the petitioner, but as per the report of the circular, it revealed the land is under the occupation of Water Resource Department, GRP, etc. Rather than taking the decision as orged by them, the Guwahati minister wrote to this office for settlement and allotment of land to the aggrieved family. Yes, GMC, you are supposed to give as per that scheme, elevation of poverty. Why you are bringing the DC into the picture?
He has come in later on, my lord, because he has got allotment of land subsequently to the earlier case.
Understood, but there is no direction. But from where they can, what will they do? I think the best option would be the DC has to allot the land to the GMC and GMC will make a building. That is the only way out. You can't give them land. What are they going to do with the land? Can they build? Do you have the money? You don't have the money for 500 rupees to pay. Where is the money for building a house?
Yes, Lordship. That most probably, Lordship, it is be better, Lordship, if a proposal comes from the Guwahati Municipal Corporation to the
This is
Deputy
the only way out. You have only forwarded for giving land.
Then-
Where is the
then we
question of
cannot
giving land? Tell me.
10% seeking 3 bighas. They are 10 petitioners seeking 3 bighas of land.
No, 3 bighas, what they are going to do?
No,
You
one
make
kattha is,
them-
1 kattha is sufficient. 1 kattha or 2 kattha probably will fall for.
Each person.
No, for all the, we can collectively.
Constructing a multi-story.
No,
we can-
somebody
we
has
can
to
take
construct
loan from
also,
the
na?
bank. 3 bighas is not essential.
So is that scheme still there? The elevation of property?
This scheme is different. That scheme is different. This is from the earlier scheme was from Potasilambai. Now this place is Solapur. Near the center.
Forget about this
And
place.
but-
They are employees.
No, this scheme is not there. Scheme is not there.
Amingaon, in Amingaon probably there is.
Amingaon, I don't have the instruction, but earlier it was instruction. Amingaon scheme was abandoned.
Amingaon GMC will have no right.
There was a initial.
Amingaon is
Yes,
outside.
That the building is constructed by NBCC.
Understood. But GMC is outside. GMC has no right in Amingaon.
That there is no as on
yes,
that there is no such scheme, madam. As on that, I was informed that no scheme of construction is there.
Then what do you propose to do with these people?
But now the issue is something different, man. Now they have gone to the deputy commissioner to get their.
Unless the deputy commissioner, what is the deputy commissioner going to go do and give them land?
No.
What will they do with the land except selling it off?
Lordship.
They will only sell it off. Otherwise, what is there?
Nothing is.
Can be allowed. And their deputy commissioner, how can they grant without making proper application?
Proper application.
And
An
why will
application
they
to
be
do.
entitled to? Unless there is some good reasons, they have to. The deputy commissioner can only allow as per the settlement rules and the government
Land acquisition
policy.
committee, they have to examine and everything has to be done.
Then
But proposal must have to come from the Guwahati Municipal.
no, it is a different thing
Individually we
where
cannot.
because it is at your behest this happened because what is the instruction here? Rather than taking a decision as argued by them, Guwahati Municipal Corporation wrote to this office for settlement and allotment of land to the aggrieved family. This is what has happened. The GMC has approached the deputy commissioner.
I don't have the, I don't have the instruction. If there is any communication from the GMC to the office of the deputy commissioner.
Then only the things can move. Because then you have to, not only an allotment has to be made in the favor of the GMC will have to construct for giving them rehabilitation. That is the only way out. There's no other way out of granting land. No, nothing doing. You may think about now there's urban housing and all this thing of the central government. They have this I think the HR does, the Human Resource Department of the Government of India. They are building construction for elevation of poverty.
Urban property.
And have you made the Union of India party? No.
No, Union of India is not a party. No.
What you are asking, Mr. Dasgupta, that cannot be granted.
Anything like that. Some relief is.
Some relief means what? You are asking is different. There needs to be something else which has to be brought in. Take out those schemes. If there is any scheme out there, then we can very well ask the GMC to do something. Take out the HRD, the human resource Department of the Union of India, they have certain schemes, how the lands can be, what are they doing and all. So if they can be brought within that, that is the only way. But this writ petition, no. Sorry.
So I have to amend the petition.
Mr. H. Sharma, the learned counsel appearing on behalf of the respondent state, has produced an instruction issued by the additional Deputy District Commissioner, Kamrup Metro. So this court have duly perused the said instruction, but the manner in which the said instructions have been given does not inspire the confidence of this court, for which the said instructions, for which this court further directs Mr. H. Sharma to produce a proper instructions in the manner as directed by this court on 29/9/2023. List the matter again on 15th of December 2023. You find out what can be done. And this I am not going to mark it with this English and all. You can give it to him. He may have a laugh in the evening.
No, laughing is the
No, you may have a laugh in which our additional district commissioner writes English. You may have a laugh.
adopted by the clerk and he might.
No, absolutely, he can't sign it. He cannot sign it and give it to the court in this manner.
It would have been more better.
You may have a laugh in the evening. Mr. S. Bora, appearing on behalf of the GMC, shall also obtain instruction as to whether, pursuant to the order dated of Justice Rishikesh, dated so and so, passed in WPC number so and so, what steps the Commissioner Guwahati Municipal Corporation had taken in pursuit to the representation so submitted by the petitioners.
Order dated 17/7/2015.
In WPC number
5870/2006.
We inform Mr. Bora. Mr. Bora must have left.
4801 of 2013.
I will inform.
4801 of 2013.
Yes, what is this?
In item number 24, I am the petitioner.
Item number 23, my lord, I am the petitioner. In item number 24, I have received the notice. Today I am going to file wakalat.
You are the petitioner?
Lordship.
In
item
20?
number 23, I am the petitioner, Lordship, and 24, I am the respondent.
Now, what do you want?
Lordship, one sometime, Lordship, for filing a petition.
Mr. R.K. Talukdar, appearing on behalf of the respondent in WPC number?
WPC number is 1650.
1650/2021. Submits that he requires an accommodation of 3 weeks for filing the reply.
I am for the petitioner.
You have filed your reply?
No, in the
Mr. D. Chaudhary, appearing on behalf of the respondent in WPC number 253/2021, submits that he also requires some accommodation for the purpose of filing their affidavit in opposition. List the matter again on 15th of December 2023. In the meantime, the parties would be at liberty to complete the plea.
Much.
Item number 23, there is an interim order.
Item number
23,
23 is which one?
Lordship,
WPC number
253.
In the interim order passed in WPC number 253/2021. Be continued till the next day.
25.
Valid period, last order is 1910.
Lordship, we are praying for some accommodation, Lordship. We have not received the instruction. নাই চিঠি দিছে কিন্তু এটা প্রপার এড্রেসত গৈছে নে নাই সেইটো এটা কথা চেক কৰিব লাগিব।
Yes. Any affidavit filed pursuant to the order?
No, Lordship, we have not received any instructions also, Lordship. May I pray for some accommodation?
Mr. H. Sharma appearing on behalf of the District Commissioner, Hemaji, seeks for a further 1 week's time for
Let it be 2 weeks.
1 week time for for filing the pleadings in terms with the order dated 19/10/2023. Place the matter again on 20/12/2023. In the meantime, the affidavit be filed by the District Commissioner Hemaji as directed in the order dated 19/10/2023 by 11th of December 2023. The petitioner, if so advised, would be at liberty to file the reply.
Well, here they are supposed to file an additional affidavit, Manu. Today morning they have filed it, Manu. To clarify their stand. To clarify their stand, they are supposed to file an affidavit. They have filed in the morning. Manu.
Not clear from the said affidavit as to whether it is the stand of the respondent that they would not proceed with the complete compensatory affidavit. Oh, so they have filed the
They have
affidavit.
filed the affidavit. They make
Mr. C.R. Sharma, na?
C.
C. Sharma, appearing on behalf of the NC Hills Autonomous Council, submits that pursuant to the order dated 5/10/2023, the affidavit has been filed by the
Respondent number 5, Manu.
respondent number 5. Mr. N.J. Khatoni, appearing on behalf of the petitioner, seeks for an accommodation for filing a reply to the
No, the reply is not required because they have admitted that they have reviewed the place, Manu, and they have shifted to any other location, Manu.
Oh, they have given?
Yes, yes.
Okay, then we can dispose of.
Yes.
So then, why you are not
They have
saying
a-
that?
Paragraph 3, Manu.
Where is that affidavit?
Oh, it is not on record, Manu. That is why.
Oh. Mr. C. Sharma, appearing on behalf of the respondent, NC Hills Autonomous Council, submits that in pursuance to the order dated 5/10/2023, the clarified stand of the respondent number 3 have been duly brought on record. However, the said affidavit, additional affidavit, is not a part of the record. It's the matter again next week.
Yes, ma'am.
We'll have it next week on 29th of November 2023. The registry shall bring on record the said additional.
Obliged, Lord. Obliged, Lord.
27.
Lordship, last occasion I was directed to obtain instruction and to file affidavit. Lordship, I have received the instruction day before yesterday. Lordship, may I kindly
So you have paid for 2022,
22-23 and 2021 and 21-22. The proposal has been sent. Lordship, that grant has not been received. Lordship, it was sent long back.
So this amount has been released.
Released.
But the proposal is in sent for 2021-22, na?
20,
What about 2021?
2021 and 21-20.
What is the status?
Well, it was already been sent.
Show me the. Okay. So when can we get it, brother? We'll get it in the first week or second week of January 2024.
In the meantime, I will open it.
Pursuant to the order dated 11/10/2023, passed by this court, Mr. J. Hendick, the junior government advocate, SAM, have placed the instructions to the effect that the petitioner have been released an amount of rupees 7,80,000 as granting aid for the period for the year 2022-23. And in that regard, have placed before this court certain documents which are collectively kept on record and marked with the letter Y. Mr. J. Hendick further submits that for the financial year 2020-21 and 2021-22, proposal for granting aid for running home for mentally ill person in respect to the petitioner NGO was submitted to the government, but the sanction is yet to be received from the government. And under such circumstances, the Learned Council therefore submits that some more time may be granted to the petitioner, to the respondents, to obtain the necessary instructions as regards the status of the said proposal for the financial year 2020-21 and 2021-22. List the matter again on 10th of January 2024, on which date Mr. J. Hendick, the Learned Council, appearing on behalf of the respondents, shall apprise this court as regards the status pertaining to 2020 financial year 2020-21 and 21-22.
Obliged.
Yes.
My lord, the respondent Kala 8, my lord, filed an affidavit, my lord. Here they have reflected, my lord, the not actual correct, my lord, figure, my lord. Not correct figure, my lord, because figure means, my lord, only in respect of, my lord, page 237, Monturumpi, they have shown the solution has been provided. In other, they have not shown.
What?
The
Where is
solution
that
and the
affidavit?
calculation, my lord.
Additional affidavit
My lord.
filed by
Respondent 8.
8. What does it say? Sections 3A, 3D, second phase 3A, 3D, additional list 3A, 3D. Land acquired is amount for the acquired land mentioned by all the petitioners except petitioner have been duly determined and the amount was been deposited. The petitioner number 3, 5 and 8 have already received the compensation amount for the acquired land and they have acknowledged the receipt of the amount and submitted unto vacate the land and not to make any further claims and objections in respect to the amount in respect to respondent number 2, 4, 6 and 7 are lying before the company as well as and when the company receives the bank account details of those periods, the compensation amount will be transferred. The compensation claimed by the respondent number 9 are in respect and as such is not entitled. How many petitioners are there?
My lord.
How many petitioners are there?
9, my lord.
Okay. So give your bank details.
I have, my lord, provided a bank. I have filed an affidavit also regarding
That amount has already been deposited, my lord. Now, my lord, position that my lord lordship passed an order for individual calculation, my lord. We have individually calculated what is the calculation, what is the amount paid. We have the annexer, my lord. If the petitioner is not satisfied with the amount,
No, if you are not satisfied, go under
arbitration,
3G5.
3G5, my lord.
But they have to give me the award, my lord.
My lord, that is the all the
This is
calculation
it.
we have given.
This is the award, 3G estimate on the basis of which you do it. This affidavit.
My lord, here my lordship may accept the page 273, my lord, my underpaid affidavit, my lord. Here, my lord, calculation is shown to be, my lord, no, my lord. other
270?
here,
Page
Two-
273,
270?
my lord. The
273.
petitioner number one received the
73 is
amount
no
of
page. We have till 272.
their calculation.
Understood? We have only till page 272. Yes, which document you are referring?
Annexer R1.
R1. Yes.
The petitioner number one received a compensation amount 26,47,311, my lord. And if he's not satisfied, he can go to the arbitration.
3G5.
Like that way, my lord, petitioner number two received the amount of rupees one. All the amounts are there. How the amounts are calculated, we have given. If he is not satisfied, he
On
can
the
go to
basis of this,
arbitration.
you proceed.
Well,
On the basis of that, my lord, he can proceed.
My lord, in case of my lord, the serial number 2, petitioner number 1, my lord, rightly, wrongly, if the accepted, rest of the, my lord, they have not calculated.
Understood. Not calculated, you go apply under 3G5.
They have to, we have applied, my lord, to give the
To
award, my
whom?
lord. No, we have earlier, as per court order, we have filed petition to provide the award. So we can go to the arbitrator.
Huh?
So that we can go to the arbitrator. my lord.
Understood.
Until they provide us, my lord.
Now you have now this one. This will be taken as it is.
My lord.
This is the 3G estimate
my lord,
for
estimate, my
acquisition.
lord.
So
And
on the
how-
basis of this, you can find.
How we have calculated it, what is the value, my lord, all, everything is there, my
So
lord.
on the basis of this additional affidavit, I give you the liberty to file.
My lord.
If you agree by any calculation on the basis of this,
Oh, my lord.
apply.
3G5 is there.
My lord, next page, my lord.
Hmm.
So here is only 15 columns, my lord. Here is 26.
Huh?
Here in the next page, my lord, next person, here is only 50 columns, my
Petitioner
lord.
number.
Key column? What column?
Columns, my lord, only 15, my lord. So here is 26, my lord. Maybe remarks
I
for
can
that at
explain it, my
25.
lord.
I don't understand. What
My
do you?
lord, here they have segregated what is the where to how to calculate it. Here is up to 26. 26 is remark column. Here next other cases they have not, my lord, join others whatever it is, my lord.
There is no ponds.
Only 15.
Do you have ponds? Do you have ponds out there in your land? No. Fishery? No. Agriculture? There. Agriculture market value they have put. Mr. Sonia, these are the documents which will be applicable. How many are there? 1, this is for
8, 9, my lord.
2, 3, 4, 5, 6. These are all the persons are there.
All the persons are there.
1, 2, 3, 4, 5, 6.
Annexer R1 is for the petitioner number 1. Annexer next is page is for petitioner number 2 and 8. And I can explain it, my lord. The my lord, second annexer is only for the my lord land, and third one is for GRAT. It was differently calculated. So
Understood. If they are aggrieved, if they are, you are aggrieved, you go under 3G5.
My lord, they have not shown the solution of the GRAT, my lord. Second, up to first, okay, my lord.
Absolutely. If they don't give you, you go as per, you'll get interest on enhanced amount.
Apply for now.
Mr. Setia, this matter started with
my
me.
lord, lordship at the motion stage also at that time lordship asked that it can be disposed of sending it to the arbitrator.
It has to go. I can't do anything.
And my lord, if our calculation of Kala is also wrong, my lord, they are not calculated it, they can approach the arbitrator and arbitrator pass the
You
order.
do
my lord.
and they will refer it.
My
My
lord.
lord, let them, my lord, because the until and
Now what has happened? Who has been appointed as an arbitrator? Yes, Mr. Borua.
My lord, the government, my lord, GAD department.
They were supposed to appoint somebody.
No, my lord, also I asked about this.
Ah.
Process is going on, that has been
Under Revenue and Disaster
now
Management
the
Department.
proper arbitration is not appointed.
Then what happens?
Now that's the problem now because they are putting to government because government is here writing to the department, government that you.
No, that was informed to me. There was another matter which I have picked
Yes, my
along.
lord, we have, my lord, we have also the Metamorpho lordship fix it, my lord, on some other date, my lord, and that.
Which matter?
My lord,
You were there,
Gogoi
na?
is appeared.
I appeared in that matter also, then we are.
I have directed, I have asked Mr. B. Gogoi.
B. Gogoi, my lord.
He was appearing for the GAD.
GAD, my lord.
Where is that
Now
matter?
this correspondence is going on. We are
time and again we are demanding for arbitrator because not only NSA, DCL, NSA, all because.
What is the number of the case?
I have forgotten, but today also I have inquired morning. What is about arbitration? Because our cases are pending, not many cases before the arbitration.
No, in that case, if that case is brought in, I can very well direct the authorities, no?
Yes, there is Gogoi was there.
Yes, Mr. B. Gogoi. If I direct the authorities to do it, because then I will say that if there is a delay in appointment of an arbitrator by them, because it is otherwise the central government who is the appoint.
In like that way, my lord.
Government appointment has to come to Ministry of Road and Transport. So this is under 1956. But we want their names who are to be appointed. We ask from them.
No, understood. But the appointment as per 3G would be by the central government.
But we always ask the government, you send the name to whom will
the person
appoint as an arbitrator.
And
Then thereafter
Who is
we
paying for the central government in this matter?
central government.
You are there?
I'm not there.
Union of India is there, na? Ministry of Road and Transport. Who is appearing?
These are here also your lordship can pass.
I'll pass that
The
order.
lordship has already disposed of in our cases also that regarding that when to make the appointment and that this position clearing this position.
Understood. If there is an enhancement,
My lord.
you see, interest accrues.
My lord.
And if there is a delay,
My lord.
interest will keep on accruing.
This for
And why the central government should not appoint?
when NSA is more than 100 cases
Huh?
and
Because of
NSA detail even with me more than 25 cases are there.
No, and the problem arose because of this. The
commissioner,
Lower Assam
commissioner.
commissioner has been.
My lord.
Is supposed to be enabled.
Yes, and can we get hold of Mr. B. Gogoi?
May direct
Or none appears for the year.
no, because the central government will be deputy central government council.
Yes, your central government.
Yes, lordship.
Why? Who is appearing for the Ministry of Road and Transport?
Lordship, in this case, I am appearing for 1 and 4. 3 is the central government. Respondent number 3.
No. Respond number 1. You are appearing for respondent 1, Miss Madam.
1 and 4. I have filed application on behalf of 1 and 4.
One is Union of India.
Yeah.
You won't be representing one, are you?
Secretary.
You are appearing for respondent number 1?
NHI DCL.
No. NHI DCL is different.
Number 3.
NHI DCL is not a party here. Or NHI DCL is there. 4. Respond no.
Completion application appointment of arbitrator under section 3 and it is
better government council. If it's been asked, if they appoint, because the director is coming, they will take the okay. Because entire matter due to this, we are suffering.
Understood.
State is suffering. Yes.
But state won't, because you will be suffering.
Yes.
But where is that other matter which is there? There I have asked Mr. B. Gogoi, because once that matter I can, because here this is not his right. He's not asking that. But that case, this court had made it out. Because it would be very difficult for this court to pass this order. Yeah. Because he informed this court that the government of Assam has
yes,
JD department wants some high official from the revenue department to be made. But it is not known whether they have done or not. If they don't do, this will have a serious consequence.
In meeting our meeting. Whatever I mean, so this is problem we are facing. The real but order is to
Now just for example, if he files an application for making a reference under 3G5, And if the central government is the appointing authority, arbitrator, if the central government does not appoint, wouldn't they come within the ambit of 11.3 of the Arbitration and Conciliation Act? No. Wouldn't they come within the ambit of section 11.3 of the Arbitration and Conciliation Act
19.
and thereby seek for appointment? I give you the liberty.
My lord, maybe other day, my lord, because some difference is there, my.
What is there?
Because, my lord, they have in petition number 3 and 4, my lord, this is my patta land. They have found as a government land. They will not decide whether arbitrator.
Whatever may be, this is a case which this court cannot decide. Mr. Saronia, kindly appreciate. This court cannot decide. If you are aggrieved by any quantum of compensation, go before the arbitrator. Now, that is why I am asking you. Once you go before the arbitrator, then only your right accrues. If you don't go, later on, you don't have the time. They have already passed the award. This court cannot change anything. Now, just for example, today the competent authority has passed the report. That is final between you and him. And if it is final, can this court, by issuance of a writ, reopen it? No. It can be only reopened by the arbitrator. Or if it is a question of the entitlement, that you are entitled, he is not, it will be only by the district judge. This court under 226 cannot. So these are very, very important aspects which are not being taken into consideration. And that is why we have so many land acquisition matters here.
I think arbitrator has the, my lord, only in case of, my lord,
Quantum
and the who will be entitled.
No. Who will be entitled? No, who will be entitled is not for the arbitrator.
Apportionment, my lord.
No. That will be under 3H4. As regards quantum, it is the arbitrator. 3G5.
But in case of our is that they have loaned from different land.
Understood. So it will, your entitlement will be more. That is your quantum. You are not challenging the acquisition proceedings.
No, man.
So you want the compensation. And you say that the compensation earlier was not paid, now it is being paid.
It is also not paid, my lord. This is not in the deposit in our account till now. Not deposited, my lord.
Understood. If it is not, the interest will accrue. They say that they have been paid, you are not. But anyways, if that be so, if you are not getting the amount, you very well, on the basis of this R1, you apply. Once you apply, then the things will happen. Arbitrator will give a decision to that effect and by which you are going to get it. But the fact that this court cannot sit over and say that no, this land is this land or that land. This is not for this court to look into.
Then, my lord, some name was not there. After filing of this case, my lord, they have filed another notice, 3G notification, my lord. He
had received the petitioner number 1, my lord, during the pendency of the writ petition. Petitioner number 1 name was reflected, subsequently published in the PD, and he received
after filing of this case.
That means that the rectification of the, my lord, mistakes that has already been done, my lord, and he received the compensation. If any he is agreed with the amount, he can go to the arbitrator, and lordship has already disposed of this type of cases, my lord, in our cases also, giving them liberty to approach the case. Is the name is the Ram Narayan Ram. Your lordship disposed of this case on that day, my lord.
No, that is the only way out.
Oh, my lord. And he is the petitioner, my lord. He knows the petitioner. He is the, my learned friend is the petitioner. And lordship disposed of this type of petition, my lord. He is the petitioner in that case. Ram Narayan Ram.
Ram Prasad, that is quite a different matter. That is only for case file, only for award, my lord. For providing the award, court directed to provide the award. After till now, they have not provided the award, my lord. We have applied for that. That is different.
We have already, my lord.
Different question is
Ram Narayan Ram. That case already is present.
Ram Prasad Sharma.
That case has been disposed of, my lord, to approach the arbitrator like that. Your lordship has disposed of.
Lordship may some other day, my lord, because
the instant no, this is enough.
No, because my lord, the last affidavit is not with me, my lord. Even my lord, I have misplaced somewhere, my lord, in December.
Mr. Soronia, that will be a very good ground when you take it in appeal.
Cannot be, my lord.
The instant petition has been filed by the petitioner, being aggrieved by the non-payment of compensation to the petitioner.
My lord, before my lord, may I submit one thing, my lord?
In respect to the lands which have been acquired for 4 lane of NH 29, bracket kilometer 65 plus 923 to kilometer 80 plus 930 in Karbi Anglong district. And for a direction to the respondent, the competent authority to announce the award of compensation dated 10/8/2020 under the relevant provisions of the National Highway Act 1956 for construction of the 4 lane Nicola. The instant writ petition has been filed by 9 petitioners seeking the following reliefs. A page 29 or a Roman 1 of the Roman 6. Pursuant to the filing of the instant writ petition, this court had issued notice on 7/9/2021 on 21/8/2023, when the matter was listed, the Standing Council appearing on behalf of the Karbi Anglong Autonomous Council submitted that the competent authority had already passed the order in terms with Section 3G of the National Highways Act 1956. However, as the said order was not made a part of the record, was not brought on record, this court directed the respondent revenue authorities to file an affidavit bringing on record the order so passed under Section 3G of the National Highway Act 1956. This court also finds it relevant that on the very date, that is on 21/8/2023, there was a submission made by the Learned Standing Council of the Karbi Anglong Autonomous Council that the petitioner number 3, 5, and 8 have already received the compensation. However, as regards the other petitioners, that is the petitioner number 1, 2, 4, 6, and 7, the compensation could not be paid as the bank details had not been submitted. The Learned Council also submitted that the petitioner number 9 had no right to receive any compensation, taking into account that the land in question was a government land, wherein the structure standing thereon did not belong to the petitioner number 9. On the very day, the Learned Council appearing on behalf of the petitioner, however, submitted that the petitioner petitioners would be duly advised to submit the bank details. Under such circumstances, this court directed the petitioners to file an affidavit bringing on record the bank details. On 18/9/2023, when the matter was listed, it was duly informed to this court that respondent number 9-8 had filed an additional affidavit on 17/10/2023. From the said additional affidavit, it reveals that a notification published under Section 3A and 3B of the National Highways Act 1956 in respect of Section 3 from kilometer 65 to kilometer 80 of Dokmoka to Loring Tepi of National Highway number 29 were as follows. It was further mentioned that the area of acquired land, village, dark, and patta numbers, compensation amounts for acquired land, and Zirat of the petitioner number 128 have been stated in the chart enclosed to the said affidavit. This court have also perused the said charts enclosed to the said affidavit and which have been marked as Annexure R1. It has been further mentioned in paragraph number 4 that the petitioner number that a compensation amount for acquisition of land mentioned by all the petitioners except petitioner number 9 have already been determined, and the amounts were also deposited by NHIDCL, that is the respondent number 4. The petitioner number 3, 5, and 8 had already received the compensation amount for the acquired land, and they had acknowledged the receipt of the amount and submitted the undertaking to vacate the land and not to make any further claims and objections in respect of the acquired land. The compensation amount in respect of the petitioner number 2, 4, 6, and 7. What about 1?
My lord, 1 has already been determined, my lord, subsequently, my lord, that we have stated, my lord.
What about 1?
Not paid, my.
Eh?
No, there is an annexure R1, my lord. That is
No. You have determined, but what about 1?
that is, my lord, in the
Paragraph number 4, you have not mentioned about 1.
my lord, paragraph number, that is, my lord, additional list, my lord, order section 3G, order dated 4/8/2022.
Understood. But where have you mentioned in paragraph number 4 that you have made the payment to the petitioner number 1?
The petitioner number 1 has not yet received the compensation amount.
Where have you mentioned that also?
My lord, the main affidavit, my lord. Or
in this paragraph number 4, you have not mentioned.
5/1/2000, my lord, I'm looking at it.
The compensation amount in respect of petition number 2, 4, 6, and 7 are lying before the competent authority. And as and when the competent authority receives the bank account details of the both petitioners, the compensation amount to be transferred to the bank account. The compensation claimed by the petitioner number 3 are in respect of government land, and as such, the petitioner number 9 are in respect of government land, and as such, the petitioner number 9 is not entitled for compensation for acquiring the government land. This court, upon perusal of the said additional affidavit, do not find anything making any reference being made as regards the petitioner number 1 to the effect as to whether the said amount have been paid to the petitioner, the said petitioner, or whether the said amount is still lying with the competent authority. Be it as it may, Annexure R1, upon being perused, reveals the names of all the petitioner numbers 1 to 9, 1 to 8, There is nothing as regards 9, no?
9, my lord. He has petitioner himself stated in the repetition that he is the president of the school.
No,
So he
understood.
filed a
No, no.
petition.
In these R1,
R9, my lord.
only
Petition number
from
9.
1 to 8,
8, my lord.
respect to 1. The above therefore shows that for the reason that the petitioner number 9 is not the owner of the land and has no, and is not a person aggrieved, the petitioner number 9 have not been paid any compensation, have not, and no compensation has been determined or paid to the petitioner number
The
9.
School represented by the petitioner, my lord. School, my lord.
Huh?
Government school, my lord.
I've heard also Mr. M. Saroni, the learned counsel, appearing on behalf of the petitioner who submits that the amount of compensation as reflected in Annexure R1 is not the amount which is much less than the amount to which actually the petitioners are entitled to. Inasmuch as the petitioners, inasmuch as various aspects while computing the compensation have not been taken into account as required under the provisions of the right to fair compensation in Namtukura Lehiri 2013. He further submits that the entitlement of the petitioner number 9, that the petition number 9 is also entitled to the compensation in view of the fact that, that the land may not be of the petitioner number 9, but the structures constructed thereupon belong to the petitioner number 9. Mr. J. Shutia, the learned counsel, appearing on behalf of the respondent number 8, however, submits that if the petitioners are agreed, submits that the petitioner number 3, 5, and 8 have duly accepted the awards, the awards without any protest and have also received the compensation. In essence, the petition number 3, 5, and 8 has no right to object to the quantum of compensation. He submits as regards the petition number 1, 2, 4, 6, and 7. The respondent authority, you have paid now.
My lord, my instruction is that they have not, they refuse to accept the amount. 3 persons received the amount, they refuse to accept it, my lord. Telephone instruction.
Submit that till date, the petitioners have not, till date, the said petitioners have not furnished the bank details.
We have provided, madam.
For which the said amount could not be disbursed to the petitioner, said petitioners. He further referring to the order passed by this court on this court, having heard, I've also heard Mr. C. Borua, the learned standing counsel, appearing on behalf of the National Highway Authority of India, and Mrs. V.L. Singh, learned counsel, appearing on behalf of the respondent number 4, who submits that if the petitioners have any objection as regards the quantum of compensation, then the petitioners have to approach the appropriate authority, and this court cannot adjudicate the quantum. From the facts narrated herein above, And from a perusal of the additional affidavit filed by the respondent number 8 and the enclosures thereto, it is found, it is seen that the respondents, that the competent authority had already submitted its report in terms with Section 3G1 of the National Highways Act 1956 in respect of the amount of compensation to which the petitioner numbers 1 to 8 are entitled to. Under such circumstances, if the petitioners are aggrieved by any as regards the inadequacy of the compensation, the recourse available to the petitioner is to file appropriate application before the competent authority under Section 3G5 of the National Highways Act, and upon such application being filed, it is the requirement of law that an arbitrator is to be appointed for the purpose of deciding the question of inadequacy of the compensation. This court also finds it relevant at this stage to take note of the submission of Mr. M. Saronia, the learned counsel appearing on behalf of the petitioner, that the reports so prepared by the competent authority in respect of the petitioners number 1 to 8 have not been furnished to the petitioner, and for which the petitioners are not in a position to file the application as is required under Section 3G5. It is of the opinion that of this court that Annexure R1 to the affidavit filed by the respondent number 8 on 17/10/2023 would be the report in respect to the petitioners as regards the determination of compensation. And therefore, this court grants the liberty to the petitioners to file the application, if so advised, under Section 3G5 before the competent authority on the basis of the computation shown in Annexure R1 to the affidavit dated 17/10/2023. This court further finds it This court also finds it relevant to take note of the contents of the affidavit of the respondent number 8, who submits that as regards the petitioner number 3, 5, and 8, the payment of compensation has been duly made. But however, as regards the respondent number, petitioner number 2, 4, 6, and 7, the said payment has not yet been made on account of non-availability of the bank account details. This court at this stage finds it relevant to take note of that in pursuance to the order passed by this court on 21/8/2023, the petitioners have filed an affidavit on 7th of September 2023, wherein the bank details of all the 9 petitioners have been duly mentioned. The copy of the said affidavit have also been served upon the Standing Council of the Karbi Anglong Autonomous Council. And as such, this court finds no reason as to why the said petitioners, that is the petitioner number 1, 2, 4, 6, and 7, have not yet been paid the entitlement as per the computation so made in Annexure R1 of the affidavit dated 17/10/2023. This court therefore directs the respondent number 8 to disburse the said amounts as computed in Annexure R1 within a period of 15 days from today.
Undertaking. They have to submit an undertaking that regarding compensation amount.
Not
They have,
necessary, my lord.
if they are not submitted, that is the reason, my lord, they are not coming and submitted the undertaking, my lord, to the authority, my lord, Kala.
That
the bank account details, receipt amount, they have to put the signature and all these things. And regarding that column is was also there, that they will not claim any compensation.
No, they
My
cannot.
lord, my lord, it is required to be rectified. My lord.
That you cannot
My lord,
do.
that, my lord. Only for
Now,
that,
then
my lord.
I say one thing.
Without
Shall
insisting,
disburse the amount.
without insisting on the other.
Paying record will be there, my lord, if they transfer.
Shall disburse the said amount to the petitioners. To the said petitioners, 1, 2, 4, 6, and 7. Within a period of 15 days from today. Taking into account the right which exists under section 3G5 to the petitioners to receive the amount under protest and challenge the computation, the respondent authorities shall not insist that the petitioner should give an undertaking that they would not challenge the computation so made as regards the compensation, as regards their compensation. Be that as it may, the petitioners are further directed to submit the indemnity bond.
My lord, that is the undertaking, my lord. Indemnity.
No, indemnity
My
bond
lord,
is
indemnity bond.
is
My
that
lord,
they will
indemnity bond.
that indemnity bond that they shall only indemnify if they are not those persons.
Yes, my
To
lord.
return
Yeah,
the
my lord.
money.
To
Accept
return
Yes.
the amount, my lord.
Accept
Shall submit the indemnity bond as well as other documents
proof of identity.
as regards as well as the proof of identity within 7 days from today. That you just give it only indemnity bond and this. This court have also taken note of the submission of the learned counsel for the petitioner in respect of the petitioner number 9. Which is the case where the petitioner, there has been no determination of compensation made in view of the fact that it is the stand of the respondent authorities that the petitioner number 9 has no right to receive any compensation. If that be so, then the petitioner would be well advised to approach the respondent authority, the National Railway. Anybody has a National Highways Act? Approach the appropriate authority in terms with section 3H4 405.
Code. Civil code.
Huh?
Civil code. PS4 civil code.
shall approach the competent authority with an application under section 3H4 and upon the petitioner, upon the said petitioner number 9 approaching, the competent authority shall make the reference to the court of the principal civil court of the original jurisdiction, within the limits of whose jurisdiction shall make a reference to the court of the district judge, Kabi Anglong, taking into account that the land has been acquired within the limits of the state court. Anything else?
No, the statement of the petitioner is that petitioner number 9 is the president of Simulwati LP School.
That land has been
He is the
occupied, wall has
school
been
is not
demolished.
the petitioner before your lordship. The
With the
president is
above observations,
my lord.
this court's the above observations and directions the petition stands.
My anxiety only is that some land has been not shown in the notification.
If that
Telling.
Is my lord that other part? my
Some
lord,
land has not been shown in your notification very well, then that land does not become a part of the acquisition. It's good for you, isn't it?
but already they have constructed there.
Ask them to break it.
Not possible for my client.
You, Mr. Sarani, you get another right for filing another writ petition.
That's why I want.
their land
to
is-
No,
pray-
no, you can't bring that here.
My-
If any land is been taken,
Without permission.
which has not been a part of the compensation, or no, it is not in the notification.
Arbitrator also cannot decide.
No, the arbitrator can't decide. Neither they can also decide. The district judge cannot also decide that. So then you can very well ask these authorities to demarcate that land, and then after that you can very well come before this court.
My lord.
Yes.
My lord, in this case,
My lord, in this case, I am appearing on behalf of the private respondent, my lord. I need 2 weeks time, my lord. For filing.
Matter pertains to what?
my lord, my lord, actually, my lord, the petitioner are the owners of land, my lord.
Huh?
Petitioners are the owners of land, my lord. Now, my lord, at one point of time, the father of the petitioner, respondent number 422, he was cultivating the land, my lord. Thereafter, my lord, he left the cultivation and the possession was taken back by the father of the petitioner. But my lord, in the meantime, the name of the father of the respondent number 426 got recorded as my lord riot in the Katyan. So on the basis of the riot in riot, my lord, they applied for
Occupancy.
not my lord
Ownership.
ownership right. The DCS my lord they issued the notice, and we filed objection, my lord. But my lord, in spite of record our written objection, the order sheet says, my lord, that we have no objection. On that basis, on the very same date, my lord, he determined the compensation and recorded the record.
Show me the order.
My lord,
Page 25.
page 25. Page 25, the next statement.
Mr. Hendrik, you produce the record.
We are leaving to file our affidavit.
Affidavit is okay, but the only question is whether when there was an objection, why did the deputy commissioner write that there was no objection? And on the basis thereof, let it decide, and after that, he who is aggrieved, he can very well go to the Board of Revenue. But the fact that when there is a written objection out there, how the deputy commissioner has written that পট্টাদাৰ পৰা কোনো ধৰণৰ আপত্তি অহা নাই. That is the only point.
That is the only, my lord, under rule 14, my lord, the compensation cannot be allowed on the cannot be assessed on the same date. They have to issue notice, inform rate.
But then also, that is the secondary. The first is without deciding that, how can that be? Mr. J. Hendrik, appearing on behalf of the district commissioner, shall Kamrup Rural is directed to produce the records in respect of reference case number 7/2019 on the next date. List the matter again on 13th of December 2023. In the meantime, the private respondents would be at liberty to file their reply. That is the only case. Mr. You got the copy?
Yes, I have received the copy.
Mr. S.P. Roy, the learned counsel, appearing on behalf of the petitioner, submits that the affidavit in reply has been filed today. To list the matter again on 6th of December 2023. Interim order passed earlier shall continue till then. Registry shall bring on record the said affidavit.
May please, Your Lordship. Your Lordship, subject matter of this petition, Your Lordship, already decided by the division bench of this court. Writ appeal number 85 of 2022, Your Lordship.
Anything happened to the writ appeal?
Writ appeal already decided, Your Lordship.
Writ appeal is allowed.
Writ appeal allowed.
So what happens now?
Nothing remains.
The situation may close.
Learned counsel, the counsel at the bar submits
11 or
that the writ appeal filed against the judgment and order dated 1/2/2021 passed in WPC number 3549/2020 was allowed, thereby reversing the said judgment dated judgment and order dated 1/2/2021 passed in WPC number 3549/2020. Taking into account that the entire edifice on which the petitioner have filed the instant writ petition have been lost. Nothing survives in the instant writ petition, for which the instant writ petition stands dismissed. The judgment and order passed by the division bench dated 17/10/2023 in writ appeal number 85 of 2022 is kept on record and marked with the letter X.
Okay.
Interim order was there.
Interim order.
Interim order, if any, stands vacated. IA is also closed. Interlocutory application stands closed in view of the dismissal of the petition.
32.
May I please, your lordship? My lord.
Yes, what is your instruction?
What you want, AVDB file, my lord. We
File, my lord.
only
Some
two
affidavit
pages.
file, affidavit in opposition file by respondent number 6.
Yes, ma'am.
Who is respondent number 6?
Is the deputy commissioner. Not district commissioner. Only one paragraph, it says, my lord, there is no government land. In one paragraph only, it says that there is no government land in and around.
What is the basis on which he is asking for land?
My lord, it's, I'm the absolute owner and possessor of the land. My land was acquired for construction of the stadium in Forusada in 2003. Therefore, no compensation paid to me, but in lieu of that, decision has come up. For short naturally, I'm telling, this is the alternative land will be provided. Therefore, we have approached this honorable court by 2003 itself on petition. Then this honorable court has placed to pass an order to find you file representative, you will consider it. Thereafter, nothing has been done. Then 2014, we have come again with another petition. Lordship, that order, if your lordship go for a time being, everything is clear on that judgment. That judgment your lordship will get in each, my lord, operating annexure 24, page 130, my lord. Thereafter, only main cause of action is coming up. Lordship got it. 130 page. That's starting. The second para is effective.
Then there was a direction to do so within 3 months.
Yes, my lord.
Thereafter, what happened?
Thereafter, they have not done anything. Thereafter, actually, in the meantime, no, it would have been contempt also, but no contempt is like. Thereafter, next paragraph, your lordship see, next annexure, it is page 25. Oh, sorry, 125, 135. Annexure 25. Not you got 4 members.
No, you have taken the land on the basis that you are going to allot some land to him.
Yes.
Why you are not doing
Alternative land. That was the initial agreement. My lord, he can either, my lord, he can take the compensation also. I do not know, because deputy commissioner only says that there is no government land.
compensation has to be worked out now?
My only
Either of that
concern, my
two
lord, because that is correct, my lord. Because either he should definitely he is entitled for compensation, because government is nowhere denying that my land was not acquired. I'm entitled. But question is coming because all along it was for alternative land, my lord. Now, DC has filed an acknowledgement. Before that, if we go and access, they have clearly said lands are available. Even lands are available. Moreover, there is a legal opinion in terms of Joint Secretary by Advocate General also. This can be allotted. This now, your lordship, if we go thereafter, only one annexure, if I go, my lordship, how they are denying, I do not, I am also not understanding, lordship, may only peruse 152 page. Or lordship may start from, it is for better year. 150 lordship got it. I'm taking from back. This because government has sought some clarification from DC. DC in turn has said to ADC Land Revenue. ADC Land Revenue asked the circle officer to furnish the correct position. Then this is the 10/1/2022, my lord. Before filing this application, there is a clear statement that lands are available. Here, if I go for lordship, my lord, by affidavit which has been filed, only paragraph 6, they have not mentioned, only it is telling land is not available. But all along there is a report was there, 4-member committee report there, rather than correspondence from DC, ADC, circle officer, government, this land is available. Now suddenly only one paragraph, 4 lines they have written, land is not available. That is why, my lord, really this is how it can be corroborated. A lordship will take into that consideration. And this regard, I have reply also in detailed reply also I have given. Because here they have clearly said, my lord, lands are available. Now alternatively it is coming today, you take compensation. But I would have taken compensation long back, I would have taken, my lord. Only I need a land. That was admitted, they were ready to pay, ready to give me. This is, my lord, this is that very contradictory.
Where is your agreement?
For which this one? My land was taken. That was, my lord, that is not agreement, notification. That was annexure 3, 64. This out of this area, my land also included. This 64 page. 64, my petition, my lord. There is no denial at all that my land is not taken. In the earlier judgment also it is clearly said. And there is a letter from this, on the basis of one letter, our honorable court was pleased to pass an order. That is letter dated 9/8/2016.
No, this declaration was made, but where is your entitlement to the
Here,
land?
my lord, listen, because yes, lordship, that I also only can say this one moment because there is no denial part here in my land is included. There is no denial on that part.
Not on that, but where is it mentioned that in lieu of the land which is being acquired, they would pay you or allot land?
No, there is no such about that, but there is thereafter it was correspondence was there. On the basis of correspondence, it was agreed.
Where?
This is lordship judgment,
No,
judgment.
this court's judgment would not do.
Because
But I'm only asking where is the correspondence to that effect to show that in lieu of the land which is being taken, they will be allotting land to you.
Yes, lordship, I'll circular officer has explained yes. In detail I can give you. Lordship.
Circle officer cannot say anything to that effect. This is a question of, this will be an acquisition made under the 1894 Act.
Yes, correct. Lordship.
If it is done under 1894 Act, then it will be done under the compensation or the award. Where is the award?
Because
we'll get something from the award. Where is the award?
Pardon?
Where is the award?
Award.
In respect of the 98 because of that. Where is the award?
Award I
There you will get something.
Because
then they will be saying something out there. Yes. Mr. Talukdar, where is the award?
I'll have to get it.
Get that. That will show. Because once that award is there,
yes,
there they will mention something as to where is the question of payment of compensation or not, or is it they will grant to land?
Some alternative.
If it is so, then obviously things will be different. It is not clear because the circle officer cannot say we are going to give you land.
No,
or even the deputy commissioner can't say.
I have written letter to them. My correspondence was there on the basis of that because the first case was for the representation.
Understood. But Mr. Borua, kindly appreciate one thing.
Yes, my lord.
This is a case of acquisition of land of yours.
That's right.
That will be subject to payment of compensation.
Yes, that is right. Record if you ought to qualify entire record whether land is available or not.
No. That is really different. First, let us see the award. Mr. P.J. Talukdar, the learned counsel appearing on behalf of the Revenue Department of the Government of the Revenue.
Not revenue, government. Other.
Appearing on behalf of the respondent state is directed to produce the award in respect to
5, 6, 7 minutes.
Declaration.
LA case number 3/2023 on the next day. This is the matter again on 15th of December, 21st of December, 21st,
December.
21st of December.
Not before.
You want it?
December.
But
Because it is a pending, my lord.
because there is the old matter na.
That is 2003 or not pending is better.
On 6th, Mr. Talga, 6th of September.
Six may not be, my lord. Marriage
Shall
is
produce
not.
the records in
Fourth,
respect of
Miller.
LA case number award records in respect of LA case number. I do not know
Three of-
what it is. On the on 6th.
Four, I think. For private. Maybe on 15. Six. Six.
Mr.
Okay.
Borua, I
Yes,
am
yes,
not
yes,
there.
yes, yes, yes.
I am not there in that week or the
No,
next.
no, that's all right.
So under such circumstances, it
No,
will
no,
not be
that's all
proper
right.
for me to fix.
Yes, 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 my lord, on six. Six is.
33.
33 and 34 notice, we are going to file affidavit, by tomorrow we can file, that today, deponent come and swear the affidavit.
Mr. J. Hendrick, appearing on behalf of the respondent, submits that the affidavit to be filed on behalf of the respondent number,
Lordship,
on behalf of the respondents number, whom?
Lordship, Superintendent, Food and Civil Supply.
Uh, on behalf of the respondent, Food and Civil Supplies and Consumer Affairs Department is ready and would be filed within this week. List the matter again on 29 on 6th of December.
6th of December. 34 also same. Obliged.
Yes.
The petitioner highest bid for Mazbar weekly open market has not been considered and therefore we have to put it forward. Record has been called for from BTC. I am the highest bidder, which is 6,52,790, and the second highest bidder 4,90,000. He has been awarded the market. And in this case, BTC, we have deposited the whole bid amount. It is the precondition of filing tender.
What happened thereafter?
Therefore, the market has been allotted to him and he is running the market.
Who?
Respondent number 7.
Who is appearing for?
Respondent number 7 is not here.
Yes. Who is appearing for respondent number 7?
No, he is not appearing in. Article 3rd.
Why have you given it at a lesser price? Huh? Why?
In fact, when the report doesn't suggest why the reason has not been given, madam.
At page number 16, your lordship, as per tender notice, page number 16, 11, point number 11. It is written that the competent authority shall make settlement with the highest bidder if all the necessary documents and government revenues are found in order. In case settlement is not made to highest bidder, the competent authority shall record reason in writing for their decision.
Then what happened? Why you are not giving it to the petitioner?
But in fact, not to call for the record. I have received the record, but the record doesn't. The entire bunch of tender has been given to it. There is no note sheet and everything, my lord.
This is the matter tomorrow at 2. Deposit.
Right.
As Bora shall peruse the records and
The record, you can show, my lord, but the record is incomplete, my lord. I have the tender, all the record, but there is no note sheet in the record.
then we say there is nothing on record. And dismiss and allow the report. Shall produce this the matter tomorrow at 2 p.m. Fine.
All right.
Lordship, before the petitioner starts, Lordship, on behalf of respondent number 3 and 4, we have filed our affidavit today, Lordship, in the matter. Maybe tag with the record.
Respondent number 3 and 4.
Neramit, Lordship.
Counsel appearing on behalf of the respondent number 3 and 4 submits that the affidavit has been filed today. Is the matter when?
Your Lordship, time is of the essence after 31st December.
What is this?
The petitioner was impaneled as a supplier at Neramac for a period. Neramac. Neramac is the Northeastern Regional Agricultural Marketing Scheme, Your Lordship. They were impaneled in the 2022. Their empanelment was for a period of 1 year. Your Lordship will kindly come to page 47 for a moment here.
Time is of the essence?
Yes. Page 47.
The respondent number 3 and 4 has filed the affidavit today.
Yes.
However, the said affidavit is not recorded. Mr. M. Sharma, appearing on behalf of the petitioner, submits that the time is of the essence and the matter requires an urgent disposal. Taking into account the above, is the matter again on 28th of November 2023, on which date an attempt shall be made to dispose of the matter.
Okay, my Lord. That's it.
We are yet to receive instruction.
Hmm?
We are yet to receive instruction in this.
Why?
Although we have communicated twice.
My Lord, we are on a very limited thing in this. But my petitioner.
What license?
This is regarding, my Lord, retail outlet, my Lord, retail license for, my Lord, running and operating, my Lord, the fair price shop was cancelled. I was running and operating a fair price shop. I was licensed by the government, my Lord, and on the ground of some misconduct on my part, so they have, without following the procedure, mostly relating to, my Lord, the opportunity that has to be given under the mandate of the order 1982. They haven't followed the mandate and they have simply cancelled my.
They have suspended?
Initially, they tried to suspend, and after suspending, there is a procedure that they need to make an inquiry. Then inquiry report has to be submitted. Then I need to be given the opportunity of hearing, my Lord. So they did not give me the opportunity to file my response, and without giving it, my Lord, during the pendency of that proceeding, suddenly they issued the cancellation order, my Lord. Then, my Lord, it has been cancelled, and we were protected by this honorable court. We had the apprehension that
What is the protection?
Protection, my Lord, that the shop which was awarded to me, they are contemplating to issue another license in the locality in the name of another person. So
But as of now, there is no fair price shop.
as of now, my license has been cancelled and I'm not operating.
There is no fair price shop.
There's no fair price shop.
And you are not interested.
Not no. We have twice. We have. And the order is not to issue any face license.
No, if there is no fair price shop,
How they are running?
something has to be done.
Yes.
We'll dispose it off. We'll set aside this and giving you the opportunity to take a step as per law. We'll do it tomorrow. Tomorrow at 2. List the matter tomorrow at 2. Because there has to be a fair price. And that too, I think you have 471.
Yes, I have 471 beneficiaries under me.
So it will have a disastrous effect on the NFSA.
Of course. I'm
List the
deeply
matter
obliged.
tomorrow at 2 p.m.
I'm deeply obliged.
Mr. B.J. Talukder, appearing on behalf of the respondent state, shall ensure that the instructions are obtained.
I'm obliged, madam. Deeply.
Yes, please, Your Lordship.
Hmm.
May I pray to take the matter on Friday, Your Lordship? The matter pertains to Lordship supply of 129 numbers of vehicles to the Forest Department, Lordship.
What is this matter?
Lordship, what happened, Lordship? I participated in a tender, Lordship. And accordingly, Lordship, I.
Forest, excise, which one?
Forest.
Lordship, Forest.
Affidavit?
Lordship, there is an inquiry going on, and we have records of that. And on last occasion, the issue was that whether we have given the petitioner a notice as well as the
But
document.
here he is also claiming 5 crores.
Yes, Lordship.
You need to file affidavit here.
Yes.
List the matter when you are filing it.
Lord, Lordship, Lordship may pick the matter on Friday, Lordship, perhaps the affidavit will not be required, Lordship, because
You
inquiry is-
forgo your right to get the 5,51,000,
because
5 crore.
the inquiry is regarding Lordship blacklisting, not with regard to the payment. Lordship.
So you are not asking for the, you are giving up your
I'm
right.
asking, Lord.
Done. This is the matter again on
Lordship,
15th of December 2023. The respondent exercise of forest. Forest. Directed to ensure, directed to file the affidavit. The Lalita, Mr. I. Botaku, appearing on behalf of the Forest Department, shall ensure that the affidavit is filed on behalf of the Forest Department by 12th of December.
Lordship, fixing it on 50th. Lordship, fixing the matter on 50th.
Huh?
12.
12th, I'm asking them to file the reply affidavit. 15th, I'm fixing it.
Yes, Lord, 50th.
No, 39 for us.
Service complete. What is this matter about?
The tender process was, my lord, challenged there, my lord. For,
Now, was there any stay
at this point, my lord.
in this case?
At
In the meantime, shall be subject to further orders that may be passed. No stay. Work has been finished.
Oh, that part I don't have. We have filed affidavit immediately after filing the writ petition, my lord. That
So the
part,
petitioner had not appeared on the last occasion also. Taking into account the office note, the service is being complete, leaves the matter for admission in the first week of December.
Contractor bill, my lord.
Why nobody is appearing?
There is instruction, my lord, to the name of
Huh?
name of the con. Lordship may see page 19, my lord.
8?
19.
Yes.
11,77,000, that is the repeated amount, my lord. After 15,20,152, and another amount 2,56,857.
No, after verification, it will be paid as per considerably.
But till now they have not paid, my lord. 60 days time has
Now,
been granted.
if he is not representing, what to do? Postal journal for memo dated 7th. You are going as per postal journal. Have you affected the service?
Last time the standing gossip was asked to appear, my lord, and their name also to be shown.
PWD?
No, not PHE, my lord.
Huh?
PHE.
Oh, PHE. PHE, you know, PHE forest, they are very difficult to get. And what is this? Water, chief engineer, water. And additional mission director, Jal Jeevan.
Public Health Department is there. Outer is dated 15/7/21, my lord, page number 12.
And they are presently working in these capacities?
My lord, I've mentioned, my lord, both of them might have retired, my lord. They pay para 10, my lord.
Huh?
Para 10, lordship.
Of the repetition, of the contempt petition.
Contempt, my lord.
The earlier, my lord, Vishwadeep Das
As per
retired.
information, the aspect went so. Retired from post office account in one and thereafter also has. You have to make the new people a party.
Then you notice the
That is why they are not appearing. How can this court affect compliance? Mr. J. Roy, the Learned Senior Counsel, submits that he would take effective steps in the matter, taking into account that both the respondents have already retired from service. This is the matter of the 6 weeks. You are there? PHE,
Yes, your lordship.
why you are not paying?
Lordship, actually, I do not have the brief. My colleague has got the brief, so can this matter be taken after some time?
I picked up the 6 weeks.
That will be taken out of different model.
Why? Understood, but the fact remains that without, how can this court initiate contempt proceeding against those persons who are not there? Yes, he is there. Mr. Bhattakur, why you are not paying the amount?
Lordship, we have received the instruction. We'll file a short affidavit. We
mean?
The department, PHE department.
Department is not there. But anyway, why you are not paying?
Lordship, the department is citing shortage of funds, so we'll submit the proposal for next budgetary year.
When?
2023 to 2024. That budgetary year, we'll submit the proposal for
next year.
Yes, Lord.
For this year?
Next year, Lordship. That is what our instruction is.
Why?
Because the department is citing shortage of funds. Lord.
Did you have anything at the time of giving the work? Why did you give the work to them? And now you are saying that you have no money.
Lordship, there might be some contingencies because of which.
Find out any contingencies remain. Mr. I. Bhattakur, appearing on behalf of the PHE department, submits that taking into account that the department is looking into the matter as to how the funds can be arranged for the purpose of dispersing the same to the petitioners. First, list the matter again on January 10th, 2023. In the meantime, the petitioner is given the liberty to take appropriate steps, taking into account that the respondent contemners are no longer in service.
10th of 24.
24. Service not complete. Service not complete is the matter after completion. Yes, contempt for what?
Contempt with regard to the water resource department.
What was the direction?
Direction was page number.
In view of that, these reasons are disposed of with a direction within 15 days where the concerned official of the state government will communicate the supplementary budget in the last assembly within 60 days from the date of receipt of the amount of bills. The petitioner shall be processed and cleared within a further 45 days. In view of the above, the respondents the entire process within a period of 4 months. It was given on 36/2023.
9.
Huh?
39/2023.
36. 36. You have issued. When did they receive it? Huh?
The notice was
Mr. Counsel.
sent to 36.
Understood, but where? How did you send it?
by register post.
Where is it? Nothing.
Postal receipts are there.
Taking into account that there is nothing on record to show that the service, that the order
Postal
dated
receipts are with
36.
me, my lord.
No, taking into account that there is nothing to show that the order dated 29/7/2022 passed in WPC number 7102/2021 have been communicated to the concerned respondents, to the respondent contemner, the contemners, the petitioner is given the liberty to file an additional affidavit showing affidavit bringing on record if there is any documents to evidence that there has been service of the said communication dated 36/2023 to the respondent contemner. 3 weeks time will be given for that.
Next date, man.
Same
Next.
3 weeks time I'm giving you. If you don't file, I'll dismiss it. Yes, giving you 3 weeks. Next matter, same.
Same.
Next matter, all
Till-
these are same
all
till
same.
48. All same matter, same order.
47, man. Till
48. 48 is yours.
No.
47 like a Yes, 48.
It's the contempt for non-compliance of the order dated 5/5/2022.
And the order dated
There is page number 11.
stands corrected. Huh?
Page number 11, man.
Page number
Page number 11.
11.
Yes, sir. This order is disposed of in terms of the.
What is
order
the direction?
This matter is disposed
This
of in terms of the
petition is
order
disposed of in
2012.
terms with the order dated 22/11.
Yes, sir. 22/11/2021.
What is
Then
22/11?
Page number 18, man. Start from page number 11, man. The written portion is there. Page number 21 down below.
Where is the direction to release?
Yes, madam. Page number 21, madam.
Page number 21. Where is the
21,
direction to release?
The respondent.
After hearing the parties and considered so and so of the demand, it is directed respondent after completing the necessary formalities which stipulated in terms with the order dated demand shall consider to pay the admitted amount to the petitioner as per the answer. Shall consider where is the direction to release?
Okay, here is given page number.
Huh?
The respondent BTC by each order dated. Okay.
Where?
Yes, madam.
And why didn't you enclose that order
Please, madam.
of 22/12/2021?
2021.
Why haven't you enclosed this order?
Madam, the earlier order they.
The order says what? This matter stands disposed in terms with that. But how will they know? What is the order? Tell me.
I have submitted representation before the authority. Madam.
Where?
There is page number 23, madam.
Page 27.
23.
23, I've seen it.
Yes, this is the representation.
23 does not show that that order, you have enclosed that order.
I have submitted this order along with this 22/12/24.
What did you enclose? I therefore submit this application along with a copy of the order dated 6/5 passed in so and so. Where is that order of 22/11 you have enclosed? 22/12.
I'm sorry, madam, there is no reason there. I have submitted that order.
Then what to do? You have to do it properly. No? This is not the manner in which you do it.
I have submitted, madam, but this is wrong. I have done.
You have not submitted that document. Mr. Counsel, if I ask you tomorrow, then look here. What do you mean by this order? That order 5/5/2022.
Madam, 5/5/2022.
Huh?
The 5/5/2023, madam, here the name of the work is wrongly recorded, madam. So
Then,
I have filed.
and
one-
you have mentioned about 5/5/2022. Okay, that is the date of the order.
Yes, sir.
And you mentioned out here in this communication 6/5/2022. My goodness.
Madam,
Careless.
wrong-
This is strongly. This is
The learned counsel appearing on behalf of the petitioner submits that he will take fresh steps upon the concerned respondents and thereupon, and as such submits, and the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant contempt application with the liberty to approach the respondent authorities afresh by serving the copy of the order sought to be by a copy of the order dated 5/5/2022 in WPC number 724/2022, along with a copy of the order dated 22/12/2021 passed in WPC number 7152/2021. Full stop. Taking into account the above submission, the instant petition contempt application stands closed on withdrawal. However, liberty is given to the petitioner to approach the respondent authorities by afresh, along with the aforementioned orders, and thereupon, if the order passed by the court still remains uncomplied with, the petitioner would be at liberty to again approach this court.
Obliged.
Service complete.
Madam.
Service complete. List the matter for admission.
Yes, sir.
Admission in the second week of December. 50.
It's also my
50 same.
same by Kawajima order is 16 and
51, 52. 51, 52. Oh. 53, what is it?
53.
Your Lordship, there is a
I'm
contempt, Your Lordship.
I'm representing the respondent, my lord, here. Last occasion, my lord, the finance department approved the budget, my lord. So now fund is asked, my lord. So now we have to send the proposal for sanctioning to the government from the directorate. So tomorrow we are sending it to the government, my lord.
N.J. Khatonia appearing on behalf of the respondent submits that the funds are available. However, certain formalities are required to be completed for the purpose of disbursing the amount to the petitioner. So he submits that 10 days, 15 days time may be granted in that regard so that appropriate steps can be duly effected. This is a matter again on 18th of December 2023. In the meantime, the respondent shall ensure that the appropriate steps are taken in the meantime, and the payment to which the petitioner is entitled to is disbursed. List accordingly.
Obliged.
Deeply obliged, Your Honor.
51 and 52 for hearing.
Why? Hearings have come on a motion day. I fixed it. No, I didn't fix it.
Lordship, here standing counsel Mr. P. Sharma.
Huh?
Mr. P. Sharma, due to his health issues, Lordship, he couldn't appear.
Hello. We'll fix it. And is there urgency in the matter?
Urgency is there, Lordship.
What is the urgency?
Of tender, Lordship.
Huh?
Settlement of TSRD, Lordship.
Settlement of tender. Okay. List the matter again on 23rd of November 2023 at 2 p.m. so that an attempt can be made to dispose of the matter.
Obliged.
23rd is, oh, this one. Okay.